All rise. All persons having business for the Honorable Chief Judge and Associate Judges now sitting en banc for the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please be seated and come to order.
Good morning and welcome to the District of Columbia Court of Appeals. It's always nice to see so many folks interested in the cases heard before the court and the case we're about to hear today. I'm joined today by our en banc court. To my immediate left, to my immediate right is Judge Corrine Beckwith. To my immediate left, Judge Catherine Easterly, Judge Roy McLeese, Judge Joshua Deal, Judge John Howard, and Judge Vijay Shankar. We're here for the en banc case in the matter of LEWKUS Turner versus United States. The appellant, LEWKUS Turner, was convicted of crimes following a trial where the jury was instructed that Mr. Turner could not claim self-defense if he provoked imminent danger of bodily harm on himself. In his original opening brief before this court, Mr. Turner argued, among other things, that the trial court erroneously instructed the jury on the law of self-defense. As part of that argument, Mr. Turner contended that Laney versus United States, a 1923 case from the District of Columbia, which arose during the infamous Red Summer of 1919, on the last day of a 3-day race riot, the defendant, Mr. Laney, was pursued by a mob of more than 100 white men. Although Mr. Laney had briefly escaped to safety of a nearby backyard, he returned to the street to go to work. This court held that by voluntarily returning to a place where he knew there was danger from the mob, Mr. Laney forfeited his right to claim self-defense, regardless of the mob's unlawful conduct toward him. The Turner case now represents the question of Laney's application to the facts of Mr. Turner's appeal. This court, therefore, sua sponte, decided to consider Mr. Turner's appeal en banc, focusing our attention on 4 issues. Should this court overrule Laney? What should the law of the District of Columbia be as to the circumstances, if any, in which a defendant loses the right of self-defense through provocative acts? Did the evidence in this case support the giving of an appropriate instruction about the circumstances in which the right of self-defense can be lost because of the defendant's provocative acts? And finally, 4, was any error in instructing the jury on self-defense, in this case, harmless? We've granted the parties 45 minutes per side. And I wanted to ask whether counsel for Mr. Turner and amicus public defender have agreed about their respective time allotments.
Yes, Your Honor. Please play.
Okay, and who will be going first? All right. Are you ready to proceed?
I am.
Thank you.
May it please the court, Jason Clark on behalf of LEWKUS Turner. I would like to reserve 7 minutes, or I'm sorry, I would like to reserve 4 minutes for my time for rebuttal.
Okay, counsel, I'm wondering if the podium is as high as it will go so that you could get as close to the microphone as possible.
It is as high as it will go, Your Honor.
Okay, well, it's hard to tell from up here. If you could just speak as loudly as possible. It's hard to hear with the acoustics. Thank you.
Thank you, Your Honor. A person should not forfeit the right to self-defense absent proof they purposely provoke the violence that makes their defensive force necessary. LEWKUS Turner should not have been obligated to withdraw or hide from the place where he made his life on pain of losing the right to self-defense merely because his tormentor, who had threatened him, was also to be found on the same streets. The law should not privilege bullies to threaten death without facing the risk of lawful force in response. The rule that has emerged from Laney is an unjust rule subjugating law-abiding citizens to unlawful and aggressive acts without due regard to the rights and dignities of law-abiding citizens.
Counsel, we've had a number of cases in this court in more recent times than Laney. We've had Andrews, we've had Sams, we've had Rowe, and we've had Watson. And in each of those cases, our prior decisions have reconciled the Laney decision in some instances not too dissimilar from the facts here. Why shouldn't we do the same here?
Your Honor, the Supreme Court case law, the self-defense cases, is very clear that what was required at common law and what is required under the district's self-defense doctrine is purposeful provocation. I think that when the court was looking at those earlier cases, none of those cases were sitting en banc. They were not specifically there to decide that issue. And looking at it critically, you cannot conclude that the Supreme Court did not actually find and did not hold consistently that purposeful provocation was required.
But didn't we rely on some of our recent cases in this court on the notion, looking at necessity, whether it was necessary in certain instances for the person alleged to have provoked and therefore forfeited or lost the right to self-defense?
I think that this court has certainly done its best to reconcile the law that has emerged after Laney with the binding precedent of the Supreme Court's opinions. But now that this court is sitting on banc and taking a fresh look at it, I think that the honest answer—
We should reverse them all, is what you're saying.
I believe that is correct, at least as far as the standard of purposeful provocation. And I would just like to, I know that the government makes a point that in the Supreme Court cases, it doesn't seem that it is absolutely necessary that purposeful provocation be a part of those opinions. But I do think that when you go back and you read them and you look at them critically, each of them stands for the proposition that it must be purposeful provocation. If we're looking at them, each one of them had, each one of the cases had, the defendants had knowledge.
You're talking about the Thompson case from the 1890s and the Baird case from the early 1900s that preceded Laney. Is that what you're referring to when you say Supreme Court?
So in the Supreme Court self-defense cases, and I think that there's four in particular that bears keeping in mind here. There's Gorko, Thompson, Beard, and the Supreme Court's Wallace, not the DC Circuit Wallace that came in 1901. But if you look at those cases, the common thread going through all of them is the requirement of purpose, where the court acknowledges that there was knowledge that each of those defendants went towards a substantial risk, and in doing so, they did not actually show purpose, and therefore the court reversed in all of those cases.
Counsel, your proposed standard does include purpose, and you're talking about getting that from the Supreme Court cases, but it also includes some other language such as a requirement that the provocation occur in the same encounter. Do the Supreme Court cases support that same encounter language as well, or where are you getting that from?
The same encounter, I would say that I probably adopted that from the model penal code. That was in part of there. And I do think that you can find the requirement for the same encounter in the Supreme Court's language and in those cases, because each of those cases dealt with, and they limited themselves to that specific moment of necessity, which I think implies also that it has to be the same encounter.
If we were going to adopt a same encounter requirement, would you think of the how many encounters do you think there were in this case?
That is a difficult question because it certainly at trial, we broke up the encounters into 3 distinct, I guess, episodes, you could call them. I would say that the requirement or breaking up the encounter, you have to look at only the last encounter and what was occurring there as far as when you're weighing something like necessity. But it doesn't necessarily go into what Lucas Turner apprehended or had in his mind as to what was going to happen as Mr. Giampi ran up and opened the door and started violently assaulting him.
So if I'm getting your drift, your suggestion is that the triggering conduct has to be the third incident here, as you might break them up, but that the earlier incidents might be relevant to people's assessment of intent or other circumstances. Is that where you're
Yes,
hinting?
I think that
Can I ask you, how would that work? I mean, there's a common law principle of mutual combat. The idea was that, back in the day, if A and B got into some kind of dispute and they decided they were going to have a duel. So they have this argument and they say, okay, person A says, let's have a duel. And person B says, sure, we'll meet tomorrow at dawn. And then they go and the plan is to have a duel with pistols, and they go and they have a duel. At common law, that was viewed as a form of homicide, and neither one of them had a defense if they ended up killing them, even though you might viewed in isolation as though there was lawful self-defense for whoever drew second. But that seems like the conversation and agreement to have the duel is not part of the same transaction as the time or incident, if you're as narrowly as you're slicing things. So is it your view that in that kind of a hypothetical, obviously, happily we don't duel nowadays, but is it your view that you wouldn't forfeit your right of self-defense or person A would not forfeit a right of self-defense if person A says to person B and person B agrees, we're going to go tomorrow, we're going to meet, and we're each going to shoot at each other. And then, person B shoots at person A then kills person B. Would you say person A has or has not lost the right of self-defense?
I think that in a lot of ways, the early common law treated the agreement to engage in a duel, as you're saying, as sort of its own separate animal. It doesn't seem that it was necessarily related to purpose at all, but I would say that the common law found that there was malice in that agreement to duel and the agreement to engage in or take, obviously, a substantial risk leading to death. But I see it as a slightly different animal from provocation itself.
Fair enough, but are you saying you think under the rule that you're describing, there would be no forfeiture of the right to self-defense? And if there is some principle that says you act unlawfully in that setting, it's some extrinsic principle about mutual combat? Is that your answer, or am I missing your drift?
My answer is I guess it's hard in this case. Certainly, I wouldn't say that there was anything like an agreement here. Lucas Turner did not go to that intersection intending to engage in a duel with his cousin, and that there was certainly not a agreement to mutual combat here. I think that would have to be its own case, and you'd have to maybe make a slight modification to the rule or not something else. It is not a perfect fit for this rule, but I do not think that is this case.
So I think it's helpful that you've described this same encounter concept, which I'll admit I was struggling with, is going more towards necessity than the intent, and acknowledging that intent could be drawn from the other things that you're describing as separate encounters. I wondered how much of all of this was really just semantics between the purposefulness and certain categories of things. Is there a scenario where the facts are dramatized enough in this case that behavior could be so extremely reckless to be able to infer a purposeful intent?
It has to be, you have to have sufficient conduct that you can infer the intent or the guise, basically the false assumption, the false pretenses that under which you are actually planning. And I think that's the importance of saying that something or the conduct has to be reasonably calculated in a manner that actually foresees that it could result in death or injury.
So if I were to revise the facts and say that they both drew down on each other in the first instance, and perhaps that Gyamfi, and apologies if I'm messing up his name, came and drew a gun first in the first instance, Turner then drew a gun. The second instance, they both drew guns on each other. We've got a pattern that over these 12 minutes, every time they see each other, they draw guns and people separate them. If he pulls up, and this is assuming facts, not stating what the record itself actually is, if he pulls up and Gyamfi's outside of the car in the third instance, he shows him his gun, says, I already told you that's a bet to whether I was going to need to smoke you, as you said. And then he starts to pull off, and you've got where Gyamfi's tried to hit him with the car and everything. All of that's there. Could that be reckless enough that he knew he was inviting a potential gun battle and deadly force against himself? To infer his intent?
I think that under that scenario, you could make an argument that with those facts, Mr. Turner was actually the aggressor in the situation. And so I think we have to keep it very separate between the forfeiture doctrine and the idea of the initial aggressor. And there makes some sense in saying that once he displays that gun and once he has indicated and given that indication to Mr. Gyamfi that he does pose a risk of death or bodily injury and that Mr. Gyamfi can reasonably apprehend that, maybe there's a justification for Mr. Gyamfi to react at that point. But I think there it's a question for the jury as to who is the initial aggressor, but it is not necessarily an issue of provocation or forfeiture.
So counsel, if you're separating first aggressor cases from provocation cases, and your position is that mere words are not enough and mere presence is not enough, and we accept that purpose is often, if you proved by circumstantial evidence. I mean, you can imagine cases where there's texts where the person says, I'm going back to do X, Y, and Z. Let's carve those out for a moment. Can you give us some examples of evidence demonstrating purpose that would satisfy your proposed rule?
Off the top of my head, I admit is very difficult, but I think that the counter to that is that the current standard lets the jury speculate as to what somebody's apprehension or how they have weighed the risks in front of them. I know that it would be a difficult standard, but it is the standard, it is the binding law of this jurisdiction. And it serves an important point, is that, and there's an evidentiary issue there as well. A person who is being accused of forfeiture is not the first aggressor, and they have exercised potentially lawful self-defense. And the only thing that should actually take away that right of self-defense is their purpose. And that, I think, largely comes from the requirement of common law for malice, because only with the purpose at that point, in this still hypothetical situation, can we find the malice necessary to actually convict of murder.
Counsel, say we agree with you and we say you have to have the purpose to incite violence by the other person. I'm just going to stick to A and B just to, A is the defendant and B is the person who responds and is killed, the decedent. So say we agree that A has to have the purpose to incite B to violence such that A then gets to use self-defense. Did I understand you to respond to Judge Howard's question that yes, we have to reverse because that's not the instruction that the jury got, but that you can't argue that in this case, the evidence would be legally insufficient for a provocation instruction? I got a little lost in where we were with what the evidence is in this case and what the hypothetical was that he was posing. So
No, and I certainly didn't mean to say that, because I would definitely say that there was no evidence of provocation in this case. The alleged provocation of simply, I guess, stopping at the stop sign, stopping in the intersection was not provocation in any sense of the word.
Well, if we're
as long as you
focusing on
use it.
purpose, you're saying you can't infer purpose from your client's conduct. Is that what you're arguing?
Yes.
Or are you relying on other limitations on this doctrine of provocation?
I think that the idea that you cannot infer purpose from this is clearly established in the Supreme Court's self-defense cases. I think it's in this court's early
And
recitation
just
of the
walk
doctrine.
me through why you think we can't, why no jury could infer purpose, like why this shouldn't be a jury question at all, why we shouldn't remand on the facts before us.
Because there is nothing about the surrounding circumstances that indicated that Lucas Turner was inviting violence or trying to start a fight.
Can I ask you, why
When
do
he-
you say that? I thought there was grand jury testimony that was admitted as substantive evidence that your client said after the comment by the decedent about "I'm going to smoke you," said it's a bet, and then said, "When I come back, I'm going to kill you," and also at one point displayed a weapon. So when you say there's nothing in the evidence that supports an inference that he was intending to have a violent encounter with the decedent, why do you say that in light of that evidence?
So I would say, first of all, that was the testimony of Angela Brady, and the grand jury testimony that you're referring to was very clearly impeached by the actual video of the incident. And so while there is, in the grand jury, you could potentially read that grand jury statement as saying that Turner had made a threat. In the context, he actually says both things in the grand jury, and he ends up being impeached with both. And at the trial, he does not remember any specific statements, as he roundly says. But the video that we have of the actual incident clearly shows that it's Turner who says, "I know." And so what he says is one person said, one person made a threat. "When I come back, I'm going to kill you." And the other person said, "I know." And at the exact moment that Angelo Brady is in the intersection, we can see Mr. Turner passing just 5 feet in front of him, and he says, "I know." And we know it's Mr. Turner, not only because multiple witnesses at trial identified that voice as Mr. Turner, but you can clearly hear in watching the video that Mr. Turner is much, much closer to the microphone, and Mr. Jompe is yelling from a much farther distance away. And so to say that, and because Mr. Brady essentially said both things, but it is clearly contradicted by the video evidence, which does not lie and it is not disputed, it has to be that Lucas Turner said, "I know," and the threat came from Mr. Giampi.
So if I get the drift of that, it's, although there is some evidence, you think that evidence couldn't be relied upon by a reasonable fact finder because it's controverted by indisputable video evidence.
I do. I think it would be clearly erroneous for this court to rely upon that.
And to what extent do you think a reasonable fact finder will leave that aside for, and do you dispute, do you think it's also true that the testimony that your client said it's a bet after the reference to smoking somebody is also contradicted by indisputable video evidence, or do you think that's evidence that a reasonable fact finder could take into account?
No, I think that's reasonable evidence of the fact finder. Though that statement does not come from Mr. Brady. Mr. Brady only reports these two statements. The "it's a bet" and the other statements are just statements that people that you can hear in the video itself. And I think that that's people arguing as to about what they hear in the video.
And why do you think a reasonable fact finder, if someone says, "I'm going to smoke you," and the other person says it's a bet, do you think a reasonable fact finder could view that as agreement to the idea that, yep, you're going to try to smoke me and I'm going to try to smoke you? Or do you think that is not how a reasonable fact finder could interpret that statement?
Well, first of all, I would say that Lucas's or Mr. Turner's response in that moment is a very sarcastic, yeah. He's walking away. There's no anger in it. He is not, and it's not an agreement. It's simply him brushing off what is an assault and a threatening conduct. But more importantly, this is the earlier This is the second episode, as we call it. And what we
Understood, but
do
to
not-
be clear, I thought you
Yeah.
had indicated that at least as we're trying to assess what a reasonable fact finder could view as your client's purpose or intent, we can take into account the earlier incidents and are not limited to whatever happened in the third encounter. Is that correct? So you're not suggesting it's not fair game to be considered because it's not in the same encounter where the deadly force ultimately was used, or are you?
I am saying that it is not, well, I certainly don't want to say that you can measure, necessity outside of that point. I do think that you have to measure the provocation that actually occurs.
Why are we
In the
thinking
moment,
about
it-
necessity? Sorry,
Yeah.
where does necessity come into this?
I am trying to make the point that we should not be expanding the time frame in which we are looking at the intention of the conduct. And so there is some period of time, about 5 minutes between that altercation where we come back. And I think that if we're looking at provocation and we're trying to figure out if LEWKUS is actually provoking a fight in those final moments in the intersection, we have to look at what's actually happening in the intersection at that time. But even if we expand the frame and we're going to look back a little bit further, there is still the very fundamental issue that LEWKUS had no idea that his cousin was at that intersection. And so if we're going to say that him walking away and going away from his cousin and saying that's a bet is somehow some further future agreement or part of the later provocation, you have to have some reason to believe that LEWKUS thinks his cousin is there at the intersection for him to go and have that fight with, or to have this deadly altercation. And there just is no reason to believe that LEWKUS thinks anyone's going to be at that intersection. He is going back to the location where he was originally waiting for Daquan Farmer to continue to wait for Daquan Farmer. And as we pointed out in our briefs,
Well, I mean, there was no testimony to that effect. That's your inference about what he was doing, or was there testimony that that was his purpose?
There was testimony from Daquan Farmer that that Mr. Turner was waiting for him to go to dinner. Mr. Turner did not testify to the extent that we have an idea of what Mr. Turner intended to do. It would be coming from Daquan Farmer and as far as his understanding of what their plans were and what they were intending to do that day. And Turner was reported as saying, he called Mr. Farmer up and he asked him to hurry up because he wanted to get out of the area. And there had been this altercation, and then we know the phone cuts off at that point.
And not asking you this to as indicative of Turner's particular knowledge or something he should have been aware of, but just to clarify the record, both Turner and Gyamfi were known to hang out in the area, generally and outside of this occasion.
Yes. Mr. Cooper testifies that, he's been longtime friends with them for more than 15 years. Each of them considers them each like family and that they would both routinely be there. Turner did live on 27th Street, which was just a couple of blocks over. There was a period of time where Gyamfi was living with the family on 27th Street as well, but not consistently through the years. And so that is the record.
Is there evidence in the record that Mr. Gyamfi was known to carry a gun?
Yes, Raven Montague was impeached with some of her testimony and her prior testimony and her prior sworn statements as far as the CPO. And so she made statements in the grand jury that she had seen Mr. Gyamfi with a gun previously. She also explained that she had recorded this video from his social media with him with a gun. And in her CPO statements, she had asked that he be disarmed. Additionally, there was testimony from Mr. Cooper, who had explained that after Mr. Gyamfi had been shot in 2019, he had started routinely and as a habit carrying a gun every day.
The evidence about Mr. Turner's gun is when he's seen brandishing it, standing, I guess, on the outside of his SUV.
And again, the only witness who reports that seeing Turner with a gun at the second episode is Brady. And it is absolutely clear from the testimony that Brady has mixed up two individuals. Now, you cannot, I would urge this court to possibly say that it's clearly erroneous, but unlike the video where we have the statement and it's clearly Mr. Turner making the statement, I know, it is not, we do not have a clear view of what is going on down at the final altercation where with the second altercation where Mr. Turner is supposedly standing on the floorboards with a gun. But it is clear that Mr. Brady has mixed up Mr. Turner and Mr. Joffe in his testimony. We have the testimony from the two other witnesses that were on scene. Neither of them saw a gun. And then we have the video, which is much closer, that came from the apartment building on our street. And in that video, you can see at points Mr. Turner and Mr. Joffe. You do not see a gun in either of their hands, but that is the video that just randomly stops, unfortunately, because it's on a motion control device that is not reliably working. And so we have these 13 and 15-second gaps from here to here, but no one else reports seeing him with a gun. Mr. Brady is clearly mixed up as about who is who. And the other witnesses on scene don't report seeing a gun at that point.
I don't remember if you reserved your time for rebuttal, but I assume you want some rebuttal time.
I did. I think I reserved 4 minutes,
All
Your
right.
Honor. But if there's no further questions, I'm happy to turn it over to Mr. Yoder.
All right, thank you.
Good morning. May it please the court, Daniel Gonan on behalf of the Public Defender Service. The undisputed common law rule is that one can forfeit self-defense only if one provokes violence on purpose. The Supreme Court embraced that principle in a series of cases in the 1890s. It is overwhelmingly the rule in virtually all jurisdictions to this day, and our own legislature, the DC Council, recently adopted that very rule. It is the rule that this court is bound to follow. The government—
When you say our own legislature adopted it,
Yes.
are you referring to the revised criminal code amendments that were adopted by the council, but then not enacted by Congress?
That's right.
So therefore are not the current law.
It's not the current law, but it's when the council was essentially asked, what do you think the law of forfeiture of provocation should be? Their answer was the common law rule of purposeful provocation. And I don't think that's surprising because every other, at least almost every other legislature has adopted that very standard, or, courts have adopted that standard where there isn't a specific statute in place. So, for this court to adopt something contrary to what the council at least tried to adopt, I think would be an unwarranted exercise of judicial power, essentially substituting the court's own judgment for the legislature's judgment on the definition of a criminal offense that is, if not exclusively the job of the legislature to define, the primary job of the legislature to define. And the rule that the government has advocated, this rule of reckless provocation, is by their own admission an uncommonly strict rule and restricts personal autonomy in a way that no other jurisdiction does. And if that's going to happen, that's something the legislature should decide. Like the legislature.
Sorry, say we agree with you, sorry, that the Supreme Court case law, common law generally across the country, the council's, legislative intent all support a rule that one has to purposely provoke violence needs to purposely provoke violence by B to lose self-defense when B responds.
Right.
Say, we're looking at this through the lens of pre-existing constructs of first aggressor, right? So we already know that if, you're actually taking an action, a violent action such that A is taking the violent action such that B has to act in self-defense, A loses self-defense under a first aggressor rule. So then we're trying to figure out what more is this provocation rule doing? What more do we want it to do?
Right.
Right? And we've already decided, well, the mens rea element has to be purpose. But then your rule, which adopts the RCCA rule as articulated by the council, imposes some conduct limitations. And I'd love to talk about those and what you think the common law foundation for those are, and what the origin is, what the justification is, and sort of whether those limitations have the effect of maybe collapsing a provocation rule into a first aggressor rule. So, I mean, just start with, I think your rule requires wrongful conduct.
Yes.
What does that mean in your view?
It has to be something that is unlawful under the circumstances, a violation.
Like unlawful, like what? Like, A defames B and says, you're a pedophile, you're a, some awful other thing. Is
That would
that?
satisfy the unlawful requirement, but it wouldn't be provocative conduct because it's not something that would be reasonably provocative to another person. So there's essentially, we're endorsing the construct essentially that the DC Circuit announced in Peterson, which I know is not binding, but I mean, the court's en banc anyway, but and that standard is deeply rooted in the common law, which required an act in addition to purpose. The act had to be affirmative, unlawful, or sometimes some cases say wrongful.
I mean, I
conduct.
see that language
Yeah.
in the common law, but it's rarely explained, right?
Right.
It's bandied about. But I had a hard time kind of understanding what it meant. And then if you couple the wrongful conduct with more than mere words,
Yes.
there seems to be at least some strand of common law that says, no, words can do it.
Yeah.
So I'm wondering if you can speak to me about that.
Sure. Okay. So just first principles, again, the standard that we propose that is rooted in the common law is an affirmative, unlawful, or wrongful act reasonably calculated to provoke. I would say there's not really much dispute, at least that I'm aware of, in the common law authorities that is the standard. Where there is dispute is whether mere words can ever be reasonably calculated to provoke someone. Some states say it can, at least under some circumstances, or really extreme, vile language under some circumstances can be reasonably calculated to provoke someone. Other states say no. It's never, no reasonable person would ever be so angered by somebody else's mere words that they would respond with violence. So the law does not recognize that as provocation. This court, or the law in the District of Columbia, is squarely on the side that mere words can never be provocation.
But is that fair to say, well, I mean, sure, yeah, the Red Book has the prohibition thing
Yeah.
saying not mere words, but that's in conjunction with, mere presence negligence standard. So it's sort of the mere words is a limitation on that. If we adopt a purpose standard, would the mere words work in a
It's-
practical, reasonable way?
Still works. The idea is proportionality. A big part of this is proportionality. And that's true. That's why if I punch somebody in the face, really bad thing to do, they can respond with defensive force. But if they respond with something disproportionate, say by drawing a knife or a gun, that disproportionate response gives me the right to defend myself. And when we're talking about mere words, we're talking about a situation where violence is by definition, as a matter of law, disproportionate. So it's not the case that even if I want you to attack me and I goad you on with mere words, that your response is proportionate to my provocation.
But
so that I can't claim
why,
violence.
I mean, that reflects poorly on the person who succumbs. Fair enough, and maybe that person would have criminal exposure for having succumbed to the extent the person
Right.
did. But I'm not sure why it should be the measure of the homicide culpability of someone who has a purpose, the prohibited purpose. And so again, worst case scenario, I'm, an evil mastermind, or A is an evil mastermind and decides that A wants to murder B, would like to kill person B without any real reason, and decides I'm going to embark on a plan where I'm going to, over a period of time, do everything I can short of being unlawful. And it could be words saying the most hurtful things you can imagine about their family or anything you can imagine, to the point where I cause that person to attack me, which is what I want, with deadly force. That's my hope and expectation. And then I will execute them. That's my plan.
Right.
And it all works according to my plan. The person who responded in that way might well have acted criminally culpably. That's fair enough. And that's what the provocation on that side of the fence can be analyzed one way. But why is it, what support, either, it's two halves of it. What support in the common law is there for the idea that an evil plan like that just can't be treated as giving rise to homicide liability? And more generally, why should that be the rule? Why shouldn't, if that's the evil plan and it works according to plan, why shouldn't there be homicide liability?
Well, part of the problem is calling it an evil plan. It's a little bit tricky because if your purpose is to kill someone, but if and only if they first attack you with unjustified force, then your purpose is to commit a lawful act, or an act that is lawful under the circumstances. And a lot of theorists have, including Kimberly Furzon, who's decided by the government, they talk about how this is a problem when we're talking about provocation and why provocateurs should lose self-defense.
Yeah, I should say, I'm not 100% sure that the word provocation is a good choice for the description of the triggering conduct, because it does lead to the idea that it's the same concept that we know from in the common law of homicide about what mitigates malice. And I don't know that those tests would be or should have to be the same, although the similar word is used. But I understand that what I was calling an evil plan. Maybe you don't think it's evil to do that. You think
I'm
that's
not
fine?
saying that
Do you
it's
think
not-
it's a fine plan, or?
I'm not saying it's a fine plan. So
Okay.
everybody here agrees that if you have a purpose to provoke violence and you do something to provoke that violence, you can't claim self-defense.
And if what I do is short of illegality, but
Right.
so that the person who responds is wrongful, and I know they're going to respond wrongfully, I'm glad they're going to respond wrongfully because that's my plan. I'm just not quite sure why that should undermine my culpability. It's relevant to their possible culpability for what they did, but why would it undermine my culpability that I was able to achieve my, cold-blooded plan to murder somebody through provocative or, triggering techniques that were short of the law, but were successful exactly as I hoped?
I mean, so I think there's two main sort of theoretical reasons for that. Number one is this is a very common feature of criminal law, is that we have this subjective mens rea requirement, and then we also require something that is like objectively frightening or threatening. That's true in like the threats law, it's true in assault law and robbery law. So if like I intend to frighten someone into giving me their wallet, and they in fact are frightened by me and give me their wallet, but I did not do anything objectively frightening to them, the law says that's not a robbery. There's a case cited in Mr. Clark's brief, Williams, it's cited for a different proposition, but that was what that case was about and what that case held. And that's true in threats, right? It's not enough for me to intend to say something that is threatening to you, and maybe I in fact succeed in you feeling threatened. If it's not threatening to an objectively reasonable person, it's not a threats crime. And same for assault. So that is a common feature in our law, and I think it applies here with even greater force because we're talking about a situation where it's one step removed from criminal intent. It's this odd thing where you're actually intending to commit an act that would be lawful under the circumstances, but we have a problem with you sort of creating that circumstance. But because this is a common feature in the law, I think it makes sense that it exists here. The other,
I'm sorry. Go ahead. I'd like to hear the other half too.
oh, so then we also have this concern about punishing people for thoughts alone. And a lot of the cases talk about this. Evans talks about this, not Evans, Smith v. State, which is the
You mean
Texas case.
words alone, or did you mean thoughts? I would be
Well, we don't
really,
wanna
really
punish
afraid
people.
if I got punished for my thoughts alone.
We definitely don't want to punish people for thoughts alone. So even if you have this idea that, you're sitting there and you're really hoping that the person across the table from you is going to attack you because you really want to kill them, but you don't want to go to jail. So you want to be able to claim self-defense. You know, that's not a good thing to think. That's not a moral thought. But it's certainly not a crime. And what makes it as crime is when you
I
do
mean, nobody's
something.
suggesting that's a crime, so.
We're
I'm
talking
not
about
sure.
words,
Right,
words
the
alone.
question is whether if.
So you have to
that
do
thought and then you
something-
successfully
right.
implement it.
So to make it something where we're going to impose criminal punishment, it has to go beyond having something merely in your mind to acting, and the action. So an act is required, and the action has to be something that is going to be not trivial or slight provocation, but provocative to a reasonable
Words
person.
can never be an action, is what you're saying.
Words are an action, but listen, if you ask me as like a empirical matter, can a reasonable person be so angered by language that they would become violent? My answer is yes. Like, I recognize that. The law has traditionally given a different answer. The law in this jurisdiction has said no. I think, or I would certainly be welcome to the court saying mere words can be adequate provocation.
Yeah,
to
right,
mitigate.
so, yeah, I mean, this is kind of my question is, as an empirical matter, you know, there's a case in the news in the last few days about I don't know if you've heard about Chud the Builder, but he's this guy who goes into very black neighborhoods and drops a lot of N-words and says words like chimping around. He recently was attacked by somebody and he shot them. And he's now being charged, I believe, with assault with intent to kill, maybe attempted murder. And to me, the idea that those words alone are not enough to they're not reasonably calculated to provoke that response is never proportional, seems wrong. That seems, I mean, I appreciate the point that, well, look, I think what you're saying is, well, our provocation doctrine for purposes of mitigation at least ought to be consistent. So if we say mere words aren't enough to mitigate a murder down to a voluntary manslaughter, then mere words shouldn't be enough to forfeit self-defense. That I get as a matter of consistency, but I don't know why the better consistency is, yeah, mere words can sometimes be enough to forfeit self-defense when you are trying to provoke violence upon yourself so that you can kill somebody and succeed. It just seems like as an empirical matter, sometimes the words are enough. So why not resolve any inconsistency that way and say sometimes they are?
I think if you're going to say sometimes they are, I think, again, I'm agnostic on whether words should be deemed reasonably calculated to provoke. But if they're reasonably calculated to provoke, then they should be a mitigating circumstance. And if they're not reasonably calculated, if the law as it stands now says nobody can ever be so angered by mere words that we're going to say that their attack on somebody else is even partially excused, then we have this mismatch.
Well, can you tell me why you think they need to be consistent? Because I'm not quite sure I see the need for
because-
consistency. So let me just pose the question.
Yeah, okay.
So the question of whether words are enough to permit someone who responds to them by using deadly force and killing somebody
Right.
to be guilty of only manslaughter rather than murder is, a question about the wrongfulness of the person who succumbs to those possibly provoking words in that way. And we could make a judgment about whether words ever should be enough. And I agree, you could have a reasonable debate about whether our current law is the better answer to that question. But it seems to me it's quite a different question. So I'm not quite sure I see the need for consistency other than that the word provocation pops up in both places.
I mean,
So
it's
that
not-
but the
yeah.
other half of it is,
It's-
if I have a plan to goad someone into attacking me and I succeed in that plan, and my whole plan is to intentionally kill them at the end of it all, why does the answer to the question of whether words, if that's part of my implementation plan or the only part of my implementation plan, why those shouldn't be enough to make me guilty of homicide? Those questions seem so disparate that I don't see why the answers to those would be the same.
It's not a coincidence that the word provocation is in both doctrines. It's getting at, and I don't agree that, I'm not saying that that's like answers the question entirely. I think you have to look to the purposes behind what provocation is doing, and in the broader context of mitigating circumstances on the one hand and self-defense on the other. But there is this deeply rooted principle in self-defense law of proportionality. And when you have two wrongdoers in a fight, that doesn't mean that neither one of them gets to claim self-defense. If we view one person's act of wrongdoing as categorically less than another person's act of wrongdoing, then the less blameworthy person retains the right to self-defense. They may be liable for, throwing the first punch, but they can still defend their life when attacked with a disproportionate response.
And how do your theories fit with mutual combat? Do you think that mutual combat is its own separate special doctrine, or do you think it would be, if it weren't for that special doctrine, a verbal agreement to fight, the next day based on whatever words might have been exchanged before that would fall outside the principle you're espousing, and it's just there's a special rule for mutual combat?
I mean, I don't think that's controversial. I don't think, I've never seen a case that treats mutual combat as equivalent to provocation. I think they're always analyzed.
And why shouldn't there be consistency there? Why is there a special rule for words of agreement of mutual combat, but not for other words that are part of a successful plan to goad someone into using deadly force so that you can execute them?
Well, in mutual combat, you have essentially like a consensual assault, and both people are consensually assaulting each other, and consent is not a defense to that kind of an assault.
That seems more benign than the conduct that I was just hypothesizing. So if
No,
if you
because-
lose your right of self-defense, if A and B
yeah.
mutually agree to use force against each other, why
Here's-
wouldn't you lose it if A goads B through words into the same?
Okay, so in a mutual combat situation, we're both agreeing there's going to be violence. Like we're going to fight, we're going to kill each other, or one of us is going to kill the other. There's definitely going to be violence. In the provocation situation, one person has the total control to prevent the violence from happening. So if I say vile words to you that are intended to provoke you, if you choose not to respond with violence,
Don't you?
then there would be no
in the mutual
violence.
combat setting, you could just not agree to the mutual combat. So I'm not quite sure the asymmetry of control you're describing.
Well, if there's no agreement to mutual combat, then it wouldn't be mutual combat. Then
Understood. My point is
Yeah.
that if you're trying to say there's some reason to have a different rule because there's less control in the goading situation in the mutual combat situation, it seems like there's full control in the mutual combat situation by both parties. You just don't agree.
Well, the difference is in the mutual combat situation, it's you show up and the violence begins. In the provocation context, if all I do is speak to you and you choose to respond reasonably and say, I'm not going to respond to your vile words with violence, I'm going to walk away, or I'm going to, just ignore you, then there is no violence. So one person is escalating it from mere words to violence. That's what this court talked about in the Bostic case, which we cited in our brief, which I think is particularly significant because that was a case about forfeiting adequate provocation as a mitigating circumstance. So like forfeiting self-defense, that was a case where the government said, you can't claim that this other person provoked you to violence because you actually are the one that provoked them. And what the court said is, no, that's not right. Bostic used mere words and posturing, and it was the other person, McFadden, that escalated it from mere words and posturing to violence. So McFadden was the provocateur, not Bostic. And the court cited the Red Book instruction on forfeiture of provocation of self-defense, saying mere words are not that kind of case.
Is your answer sort of lie in a sort of relative moral culpability of the parties that in a mere words as provocation scenario, the law chooses to protect the nonviolent actor who merely spoke over the one who instigated the violence? Whereas in a mutual combat scenario, you don't have that disparate moral culpability. They're both equally morally culpable, and there's just a standalone rule that we don't want people to be allowed to agree to mutual combat. Is that part of your
Exactly
answer?
right. I do see I'm down to 1 minute.
Well, I
oh.
want to, you're going to be up here for a little bit longer, sorry. Stemming from Judge Steele's question, do you want to reconsider your answer about whether or not you are agnostic then about the mere words limitation on provocation if we're still using that label, recognizing that Judge Steele, I think, makes a good point that maybe we should call it something else. So that's my first question.
Well, as representing the Public Defender Service, I think we have an institutional interest in mere words being enough to satisfy mitigating circumstances to produce a crime for murder to manslaughter. So that's why I said I was agnostic. I mean, we would sort of welcome.
Right. I mean,
that
there's a
as well.
world where we could
Yeah.
say they're conceptually distinct. And so, if you go with Judge Steele's,
But if you, yes.
I mean, sorry. So my next question is,
That judge.
that judge, that good friend over there.
Yes.
Yes. It's been a long night. My next question is, what about the mere presence limitation?
Yeah. Okay, so there are
because
Uh,
that's distinct from mere
right.
words.
There are
Yeah.
dozens of cases. that
Presumably, you're not agnostic at all about
I'm
that.
not agnostic
Okay.
about that. Okay, so there are many cases that we've cited, just a sample of them, that talk about the specific context where you have a purpose to provoke violence. You approach the person you want to provoke, but you do nothing once you get there. That is not forfeiture of self-defense. And I think that even more than the speech really encapsulates the concern about punishing people for thoughts alone. Thoughts
And
that
would
they-
you distinguish like a stalking situation? I mean, where you're not engaging with the person at all, but you just keep showing up? That would that be more than mere presence?
Yes.
So
Why?
that seems like the only example that satisfies your encapsulation of the rule, perhaps, because it's wrongful conduct and it's more than mere words and more than mere presence. The only one that I can think of, not to cut off Judge Easterly, but stalking. Is that the only one that?
No, there's, I mean,
What
there's hundreds of cases that have said people provoked violence and couldn't claim self-defense by doing all sorts of things. Like there's a case, somebody like smashed somebody's car windows, or you take their drink and you pour it on the ground. There's all kinds of things you can do.
But but that doesn't collapse into first aggressor.
I don't think that what those.
Because
people
it's not
would be.
directed at the individual.
It's directed at property. And there are, I think there's potentially some gray areas on the border of like, well, maybe we're not prepared to say this crossed the line and made you a first aggressor, like sort of displaying a gun. Some states would say that's not an act of aggression because you're not threatening to imminently use it, but some people might say, well, that's provocation because you're suggesting to the other person that maybe they should attack you and then you want to attack them back. So there's all kinds of situations where, this has been the law for centuries, and courts have been confronting these issues for centuries. And there are cases where they found the provocation standard was satisfied by purposeful, provocative acts that were reasonably calculated to provoke. That maybe you could have, some of those, maybe you could say, well, that would have also satisfied a first aggressor standard, but some of them certainly wouldn't.
So if A says to B, over and over again, every time A meets B, I'm going to kill you. Watch your back. At some
Yeah.
point, I'm going to kill you.
Right.
And it's with a plan to cause B to overreact to that.
Right.
And then hopefully have a self-defense claim when B overreacts. And so then it can get away with murder. And there comes a time when then, finally A shows up yet again, after doing this for weeks,
Yeah.
shows up. And so we have his words, wrongful words, because that's threats. So at least they're wrongful words, but it's only words and his presence. And B then, pulls out a gun and A shoots B very happily, thinking my plan has now succeeded. Would you say that is covered or not covered by the rules? You would understand it. Would there be forfeiture or not forfeiture?
Yes, forfeiture.
You have forfeiture.
Yes.
Because what is there more than words and presence?
Well, I think that would be covered by, that would make you an initial aggressor because you're putting, the other person is reasonably in fear that you are coming to kill them, and you've told them that, and
Right.
then you've come to kill them.
So you think sometimes the issue for you though is that that would fall outside your forfeiture rule because it's mere words.
Wouldn't be provocation.
Right, it falls
Yeah.
outside your forfeiture rule. It's
Right.
just that there's a separate doctrine. So the question would be whether that course of conduct was viewed as provocation that warranted the deadly force, and it would depend on whether B acted lawfully. If B overreacts, then A gets away with murder, and if B is acting lawfully, then A loses the right of self-defense on a first aggressor theory. Is that how you'd analyze that?
Yes.
And why should the success of that plan turn on whether B did or didn't overreact? Right? Why should homicide liability turn on whether B?
It doesn't. It's covered by a different doctrine. So
No, but if you're saying that A is guilty of homicide in that theory only on a first aggressor theory, and whether he is a first aggressor, he or she is a first aggressor, depends on whether B acted lawfully in using deadly force given the circumstances.
So I think that if you have put somebody in a position through your conduct, including words, that you are coming to kill them, and they reasonably believe you are coming to kill them, and so they would be lawfully defending themselves from that reasonable belief, and therefore you are the initial aggressor. It's not a disproportionate response. I think it is. This has come up a couple of times. I just want to emphasize, I do think it's important to keep these doctrines distinct. Some courts sometimes lump provocation and aggression together, but they have have different purposes, they have different rationales, and they, as a body of law, cover the situations where we would want self-defense to not be available and leave self-defense available where it should be.
Can I ask you to clarify something, just take you back briefly to the wrongfulness question? You said that you described the RCCA as, stemming from the common law and
Yes.
returning to the common law. And you also described your own statement of what the standard should be that way. But is it correct that your statement includes the wrongfulness aspect and the RCCA doesn't? And do you see that as a deviation? And if so, can you explain why? Or is it just something you think is implicit in the RCCA's version?
The RCCA chose to carve out speech and presence in particular to say those things will never be provocative, even if there's a purpose of provoking violence. I think that's, well, I can only really speculate. They did explain, that they cited Laney in the committee report and said, that they said we're trying to improve the consistency and clarity of the law, and but there isn't like a really detailed explanation for how they landed on that particular standard. But it obviously was very important in the council's view to exclude speech and presence. I think that's a situation where you can imagine having very serious concerns about First Amendment rights and protesters who've been threatened with violence. And we don't want those people to be, we don't want a chilling effect that somebody's gonna say, oh, they did it on purpose. They purposely wanted violence so they could defend themselves. We don't want like misjudgments about people's purpose to cloud their ability to go out and do things, particularly things that are constitutionally protected like speech and protesting. But why they didn't choose to just parrot the Peterson standard or the common law standard, I really am not in a position to say.
Can I ask you,
Yeah.
you've said that I think you've suggested at least that the limitations that you are referring to, so words are not enough, presence is not enough, reasonably calculated, and wrongfulness, you think those are deeply rooted in the common law? I think all of them. Is that your position?
Okay, it's a little bit of a tricky answer. I would say everything but speech, because again, I acknowledge this split on whether speech it can be reasonably calculated.
And
to provoke.
this is, I guess, back to something we haven't touched a lot about. I don't mean to get into the full debate of it about what our common law authorities are in this area. Is it your sense that we're free with respect to the limitations to do sitting en banc what we think is best? Or do you think that some of the concerns you have about the function of this court in the definition of common law crimes means that we need to be determining what was firmly established at common law, and we are bound by that even when sitting en banc? With respect to these limitations, I'm just unsure what your jurisprudential theory is about whether, like, right, if something's not rooted in the common law, but it's in the RCCA, is that something we can go ahead and say, well, that sounds good to us? Or how free do you think we are to adopt such limitations on this principle as seem good to us, as
Okay.
opposed to being bound by a common law constraints?
Gotcha. So, I mean, let's take speech for example, because I think that's the most, to answer your question, the most, as I acknowledge, the sort of most controversial aspect of this. So, I mean, I guess, let's say the court said, we think that reasonably calculated to provoke is deeply rooted in the common law. And therefore we're bound to, we can't expand the meaning of the statute that Congress enacted. Congress would have understood that limitation. So we can't expand provocation to include acts that are not reasonably calculated to provoke. But on the specific issue of whether speech is something that's reasonably calculated to provoke, their common law authorities were split. So we can decide as a court whether we think speech is reasonably calculated to provoke, although we have to do it taking into account, whether we want to potentially overrule precedent in other contexts. One other case I wanted to mention, Cooper says, Cooper v. Department of Employment Services was a case that said speech can't be provocation for purposes of forfeiting your right to compensation under the Victims of Violent Crime Act. So I understand it's a different context, but still, it is talking about provocation of violence as a forfeiture concept.
Can I ask one wrinkle? When you were saying what we can't do,
Yeah. Sorry.
You were focused, in your view, you were focused on the inability of this court to expand a criminal offense beyond.
Narrow.
I was about to ask,
Yeah.
I just wanted.
I acknowledge that. Yes,
I just
you
wanna
can't
make sure.
narrow it either.
Do other jurisdictions that you've referenced in your briefs where the common law requirement is purposefulness, have they included or excluded references to speech and mere presence?
So speech, there's a split. Some courts have said, just as there is for mitigating circumstances. So definitely there is a split on speech. For presence, I think every court that I know that has actually addressed the issue has said you have to have some act beyond presence. I think the best case the government cites is State v. Short, which is a Louisiana case from 1908. And I think that case is actually pretty telling because just the year before State v. Short was decided, that case had come up on appeal to the Louisiana Supreme Court, the same case, and they reversed. And they said the instructions didn't make it clear enough that it wasn't enough to go and confront somebody with the purpose to provoke, that you had to actually do something once you got there to provoke him. And then when it came up again after the second trial, they said under the peculiar circumstances of this case, where somebody, two people had fought, separated for a couple of hours, and then the defendant went to the bar where his adversary worked and he wasn't there, and somebody told him he was at this restaurant. He goes to the restaurant and he stands there in front of this other man, and the man offers to shake his hand and says, "Let's not fight anymore." And the defendant says, "No, I don't agree to stop the fight." They said under those circumstances, his appearance there could only have signaled either renewal of hostilities or squashing the dispute. And where he expressly declined to squash the dispute, he was in a sense an aggressor or provocateur, and therefore he couldn't claim self-defense. But yeah.
Yeah, so counsel, especially on mere presence, how much are we just playing in the fringes and how much work is this actually doing? Because every situation is going to have context, right?
Yes.
I mean, and for sure, there are examples that we could hypothetically think up of where mere presence is enough. I think the red summer is perhaps a great example of that. But how much work is that limitation really doing in your view in our current times?
I think it's important because of this concern about punishing people for their unexecuted thoughts alone, which is particularly important where we're talking about this context where I said before, where we've got this sort of logical puzzle where if the intent or the purpose is to kill only if somebody else attacks me with unjustified force, we're not even talking about a traditionally criminal intent. We're talking about an intent that is one step removed from criminality. So you need to have some kind of action that is reasonably calculated to provoke.
I think the intent is a little bit different from that. I mean, I think in settings that you and Mr. Clark have argued shouldn't be covered by a proper self-defense concept. I mean, people in dangerous neighborhoods or in uncertain circumstances might well have an intent to use deadly force only if and only if there's a need to do so. That's a general intent. Probably all of us have.
Yes.
So the intent is worse than that. It is a desire to create a situation where there is an opportunity to use deadly force.
Totally agree. And that's
So
why
a little bit worse.
I totally agree, which is why nobody's disputing and really nobody's ever disputed that you can't claim self-defense, but you have to actually do something to execute the thoughts in your mind.
And the issue is just what you have, like,
And then
how much,
and
how
as is
much you have to
typical,
do to
yeah,
execute, especially if you succeed. The
And
question is
as-
how much you have to execute.
as is typical in the law, for threats, robberies, assault, it has to be something that is objectively frightening or provocative.
And can I ask just a bookkeeping question? I want to make sure I believe this is right, that you have not advocated, although you've advocated for the limitations we've been discussing, you have not been advocating for a same incident, same transaction limitation. If I'm remembering, I didn't see that in your brief. Am I misrecollecting, or is that something you are advocating for?
We didn't express a position on that specifically. I think it's already established in this court's cases, which I didn't cite because we didn't take a position on it, but I'm happy to submit a 28K letter, but there's a case called Rory, another case called Tibbs that talks about disengagement. And when you have two people who are in a tense situation and maybe one of them seems like they're really trying to take it to a violent area, but then they separate and there's a passage of time. then you only look at who provoked the final encounter.
That incorporates this withdrawal concept, which is in the RCCA.
Yes, it's
Um,
also in Roe. which is the
But
Supreme
what
Court.
if there's no withdrawal, right? What if, A is, sort of tracking B and B keeps eluding A? So you wouldn't call that a withdrawal situation, certainly
Yeah.
not by A.
I would
do you
call
think-
that the same encounter, I guess.
Okay.
Yeah. But I do think withdrawal and disengagement, to the extent those are two different things, those pretty much capture the universe of this same encounter principle. So if there's been no withdrawal or no disengagement, then I think we would say, okay, it's the same encounter.
We've been talking a lot about provocation, if that's what we're going to call it, in the context of use of deadly force.
Yeah.
Do you have any thoughts about how this plays out in a non-deadly force situation?
I think it plays out. I
Is
think
it
the rules
exactly
are-
the same?
The rules are the same, but obviously something could be less provocative and reasonably trigger somebody to with non-deadly force.
And you think that, so you referred earlier to the principle that if I am the first aggressor in a non-deadly force setting,
Yeah.
so I shove somebody,
Yeah.
and the person then pulls out a gun and
Yeah.
attacks me with deadly force, I regain my right of self-defense as against deadly force. And I assume then you would think that a similar principle would apply. So if I, with a plan to get into an altercation of non-deadly force with someone, go and shove them and they respond by attacking me, just as I was hoping.
Mhm.
But then all of a sudden it spins out and they pull out a gun, that I would have lost my right of self-defense with respect to non-deadly force, and I might be culpable for an assault, including maybe even, I would have been culpable for the whole assaultive encounter, but that I regain my right of self-defense if it escalates to deadly force. You think the same principles would apply as between the two levels of this doctrine as you're describing it?
Yes, I do. I don't think that's super controversial. I mean, a lot of the treatises and cases talk about that. There's something I wanted to
What
say.
about a bear twist while you're thinking of that thought?
Yeah.
To stretch you further of you and I being near beard doppelgangers, and we decide that there can only be one. And we have a history now of where we fight every time we see each other.
Yeah.
This is an unrealistic hypothetical, but I know you were
I
going
hope
to
so.
be at the hotel bar at 5th and H.
Yeah,
And that's where you go, that's where you and your coworkers go. And I decide to go there knowing the likelihood of what's gonna happen. And then you pounce on me. Non-deadly force, all that, I still have self-defense and that's on you.
I think if anything, that would be a mutual combat situation. I think, mutual combat can be established by express agreement or an implied agreement. If we just have an understanding that whenever we see each other, we're gonna fight, and neither one of us says, I don't want to fight anymore, then it would be a mutual combat situation. What I did want to say in response to Judge McLeese's question is that proportionality principle also exists in mutual combat. So if two people agree to have a fist fight and one of them decides to pull out a gun or a knife, then the other person would regain their right to self-defense. In fact, under, in the era of Blackstone, that was the universe of self-defense. Anything else would have been considered a justified homicide rather than self-defense.
Unless anybody else has any more questions, we've taken you way over your time, but we'll
Understood, Your Honor.
reserve your time for rebuttal.
I appreciate that. Thank you.
Excuse me. Good morning, and may it please the court, Dan Lenners for the United States.
Morning.
For over 100 years, the law in this jurisdiction has not required purposeful provocation to forfeit the right to self-defense. The reckless provocation standard currently embodied in the Red Book instruction is consistent.
That wasn't the standard in Laney, was it?
The wording is not the same, Your Honor. That's true. The Red Book.
But wasn't the standard either. Laney seems to suggest something more in line with a negligence standard, whereas the Red Book instruction is language more in mind of a recklessness standard. And I just was wondering, if you're asking us not to overturn Laney or to do something like affirm or reaffirm the Red Book instruction?
We read Laney's reason to believe language as akin to a recklessness standard. We think his conduct in that case, as described by the court, was reckless, not merely negligent. We think that the cases applying that standard have generally looked at it as a recklessness standard, including Andrews, which talked about knowing and unnecessarily engaging in the act. And so regardless, we think the correct standard is, as currently embodied by the Red Book, a recklessness standard, which is consistent with self-defense being a law of necessity, general principles of criminal liability, and the need to protect life, which is the most sacred thing the law can protect.
Actually, did I understand you correctly to indicate that your position is that Laney was correctly decided on its facts?
Yes, Your Honor. The government's view is that Laney was correctly decided on its facts, where he had a safe means of escaping the backyard by going in a different direction. And instead, he checked his firearm, causing it to go off, and then went back to where the crowd was that had just threatened him, effectively, as the court found, knowing violence.
How do you square that theory with where we are now on duty to retreat? Because if we're a middle road jurisdiction, you would think the jury in Laney ought to have been instructed, if you're in a middle road jurisdiction, not that there's no right of self-defense, but that to the extent Mr. Laney could be viewed as having an avenue of safe retreat, that would be taken into account, but the jury would still have in front of it an issue of self-defense.
Well, this court has said more recently that you don't look at the need to retreat until the violence has occurred. So Laney was not a need to retreat case. It was, can
He's
go
host
back
by
to
a
the-
mob. You don't think that the duty to retreat would come into play? I mean, as a consideration under the circumstances, that seems maybe a misreading of our case law.
In
The
those
violent situation is happening.
But he has safely escaped to the backyard. There is now a break in the violence.
Mob is still out there.
It has turned its attention to the house across the street. We
So
think
it's a
under
separate
those,
transaction now?
I think it's still the same transaction. I think that under those circumstances, the government's view is that the person who goes back in front of the mob, knowing that it's going to attack them, is properly held responsible for the violence that results. Even if they didn't intend it, they certainly knew that
It
violence.
just
was going
seems
to
like
result.
that, I mean, this seems to be why we couldn't possibly endorse a recklessness standard. The government seems to be making the argument for us. I mean, because why would we turn the safety of citizens over to the rule of the mob and let the mob control the streets and have people, have to cower in backyards and in their homes without, losing their right to self-defense if they are attacked by the mob. I was listening to the news this morning and I heard a report about the recent attack on House of Worship, and I was thinking about how there's been a spate, there are just constant reports of gun violence, and it made me think of this hypothetical. I'm a licensed gun carrier. In my hypothetical, I'm taking my child to school. I drop my child off. As I'm leaving, I see someone who is armed going towards the school, and it looks like they're going to go into the school with a weapon. And I'm very concerned that they're going to go perpetrate violence, and I engage that person. Perhaps not wisely, it's maybe not a good plan, but I'm trying to get the attention of the security guard, and I start berating this person and saying, hey, you gunman, you think you're so tough with a gun. And I start insulting them loudly. And then they turn and face me and start walking towards me and look like they're about to pull a gun on me. And I pull out my gun and I shoot them in self-defense. You could say my conduct was reckless. But have I lost my right to self-defense because I engaged with a gunman who is about to walk into a school to perpetrate a school shooting? Is that really where the government is going with this?
The standard that we are supporting has a necessity requirement. And so if you are engaging
I
with that
don't know
person.
what that means. The government says necessity countless times in its brief. But necessity is sort of a broad principle that we then distill into factors, right? Where we say, well, because self-defense is the law of necessity, also, we take into account reasonableness and human nature. We have certain requirements about when self-defense can be exercised, but we don't apply necessity as like a standalone factor. I think we've made that pretty clear, no?
The necessity requirement in self-defense
I guess my question to you is what necessity
in
requirement?
the self-defense instruction is akin to the unjustly requirement in recklessness that juries apply all the time. To act recklessly, a person has to consciously and unjustifiably disregard a risk. And so juries on the facts are going to
In my
evaluate.
hypothetical, I unjustifiably disregarded a risk, right? I confronted an armed person who was about to go into a school to shoot up a bunch of kids.
If
And I
the
did
person-
so in a good Samaritan way, not in an attempt to get that person to shoot at me. I was hoping that I could, have a different purpose, that they would be stopped. But why wasn't that reckless, and why shouldn't I lose my right to self-defense in my hypothetical?
Because it was justifiable conduct to protect the students in the school from an armed gunman.
But it was reckless.
There was a substantial risk of violence, but it wasn't unnecessary or unjustifiable. Recklessness doesn't simply turn on ignoring the substantial risk of violence. It also has to be unjustifiable or unnecessary under the
So
circumstances.
your rule has conscious disregard of a substantial risk as an element, as well as knowingly and unnecessarily placing the person in position. And your response to Judge Easterly's question is that a jury could reasonably find that it was not unnecessarily, Judge Easterly was not unnecessarily placing herself in that position, but was perhaps necessarily placing herself in that position. Is that?
Yeah, no, that's the government's.
Well, we have some of the prior common law from the earlier Supreme Court cases that preceded Laney. So I think it was Thompson, for example, where person knew that the person down the road was likely to attack him or didn't like him. But that road was reasonably necessary or most reasonable route to where he wanted to go. And so I wonder if the government's brief over construes necessity in a more outside of the legal context, because I think in the legal context, we're looking at what is reasonably necessary. And it shouldn't be reasonably necessary to require the non-criminal actor to take extraordinary steps outside of their own daily life, like Laney, for example. Shouldn't have been reasonably necessary for him to avoid going to work, his employment, and crouch and hide from an angry mob. And so I wonder, having in your briefs sort of conceded that the Laney rule causes law-abiding citizens to give up some of their autonomy, if that requirement in your articulation of the rule is somewhat in tension with some of the things that I think were reasonably conceded in the government's brief.
I hope these two things aren't in tension. I think the government has been consistent. We do understand reckless provocation is protective of human life at the cost of personal autonomy as compared to a purposeful provocation standard. There's no dispute about that. There will be more violence under a purposeful provocation standard than there is under a recklessness standard. That's true both as a matter of empirical study.
A lot of larger jurisdiction, I know that your brief cites to the notion that in DC, we have a particular concern about violence and protecting public servants as well as ordinary citizens. But other jurisdictions that are larger and also have concerns about crime have adopted the purposefulness standard over any recklessness standard.
It's true, Your Honor. We don't dispute that the vast majority of jurisdictions and the common law had a purpose to provoke standard. The district is a uniquely urban jurisdiction with, the country's leaders live and work here. And we think that, and this court has in
And
other.
citizens in Ward 8, like Mr. Turner and people in the neighborhood who also have a concern about violence and public safety live here too.
Correct. The innocent bystanders who are victims of gun violence and who are potential victims of unnecessarily provoked confrontations. And this court has not hesitated in the self-defense context and others to adopt a different rule than other jurisdictions have adopted.
I guess what troubles me, counsel, is your rule takes no account of the wrongdoer versus the righteous, that the law protects the wrongdoer in your scenario, but not the righteous. So, the example is, I've got a neighbor who lives 5 houses down from me who says, you ever cross my path, I'm gonna kill you, I'm gonna kill your kids. I could go the long way around. Like I could, go a couple blocks out of my way and go up. Or I could go and instead of letting that neighbor get the drop on me, I could try to confront them. Let's say the cops have been of no help. They say, we don't believe you. This is an upstanding citizen, but in fact, this has happened. Why? Why put the onus on sort of the innocent person going about their day to conform themselves to avoid the dangerous menace up the road, instead of saying the law doesn't care that much about protecting the dangerous menace up the road? They have really brought the trouble upon themselves by sort of promising violence upon mere sight of somebody. Why isn't that the better view?
I think because the law views life as the most precious thing it can protect, and in requiring you to go slightly out of your way to avoid your neighbor, it is highly valuing life, not only the wrongdoers, but yours, your children's, and the innocent people that might get caught in the crossfire when you have a violent confrontation.
Does your rule also apply to non-lethal self-defense? Let's say I'm a Vikings fan and Philly's not too far away and I want to go to an Eagles game dressed up in Vikings gear. And I know there's a decent chance somebody will try to pick a fight with me. Do you think I have forfeited my right to punch back if I get attacked?
I don't think you forfeited under those circumstances. I think you can necessarily go to a Vikings game to which you have tickets, but I do think it applies beyond homicide.
I'm positing that I'm reckless under your view. I'm aware, I've been to the link before. I'm aware of a substantial risk of violence. And I'm going anyway to support my team, despite knowing that maybe I'll be in for an attack after the game. So I've satisfied your recklessness standard. So why haven't I forfeited self-defense under your view?
Because you also have to unknowingly or unnecessarily place yourself in.
I don't need to go to a Vikings game. I could stay home.
I think a jury could find that it is necessary when you have tickets.
Right,
it's not unjust.
But a jury could find the opposite too. And so I do struggle with the idea that it's an adequate limit to some of the concerns that the word unnecessarily without further guidance is in there. I mean, I think a juror could easily react to Judge Deal's hypothetical by thinking he didn't need to go to the game. If the test is necessity, then Judge Deal's, hypothetical is on the wrong side of your line. So if you don't mean, so you're not understanding the word necessary there to mean there was no other possible choice. You are using it, you're thinking the jury might understand it in a much weaker form of in a formulation that the Chief Judge Blackburn-Riggs used, like reasonably necessary. Is that where you're headed, or?
I think of it as akin to unjustifiably in the jury instructions that you have a recklessness requirement. That it sounds in self-defense because it's unnecessarily.
So I don't have to move, for example. Judge Deal's hypothetical, if my neighbor says, move out of this neighborhood, I'm going to kill you or your family, you would say, well, I mean, I don't have to live in this neighborhood, but I have a reasonable right to remain here. And that would be an undue response. It'd be unduly burdensome to expect me to have to move to avoid that confrontation. Would you agree with
Yes,
that?
we think that.
And how about if if I ride a motorcycle and my neighbor doesn't like that it's loud and says, ride your motorcycle again, I'm going to kill you. Would you say, you got to not ride your motorcycle in the neighborhood? Where on the necessity line would you think that should be put? Or do you think that's just up to a jury without any guidance about what's necessary and what's not?
Well, I have two answers. One is you should call the police. Your neighbor has threatened you. And that's the standard of a purposeful provocation.
Again, assume I have and that hasn't been successful, then what am I supposed to do?
So it may depend on why you're riding your motorcycle. If you're doing it to annoy your neighbor, that is unnecessary. If you're doing it to go to work and that is your transportation to work, you don't have a car, then the jury may well say it was necessary under those circumstances.
If I have a bike, I mean, all that would be submitted to the jury and the jury would be making some kind of an unguided judgment about, well, how important is it to use your motorcycle instead of your bike? And that's what the issue would turn on.
I mean, I think it's again, it's akin to the recklessness unjustifiable standard, which is again, typically a jury question.
Can I ask you about the issue, the topic of necessity, because the United States puts a lot of emphasis on the idea that the law of self-defense, and in particular, the law of deadly force, is a doctrine of necessity. And there's a lot of case law that uses, and common law authority that uses that phrase. I think that your opponents argue that, again, necessity is an ambiguous term, as we've just been discussing about how strictly, absolutely necessary a thing has to be. And so I just want to make sure whether you agree or disagree with one principle of law that I think is well settled, the common law, and I think there's support for here, which is if A runs up to B without justification and shoves B, and B responds by first shoving back, and then A shoves again. I mean, A is the aggressor and A is guilty of assault up to that point. But then B unpredictably pulls out a gun and, points it at A, and there's a struggle. And in the course of that, A ends up using deadly force to avoid himself or herself being killed. Do you agree that there is a right of self-defense with respect to the use of deadly force, even though A was the first aggressor with respect to non-deadly force? Do you agree with that proposition?
I do, although it may be limited. So there are common law authorities, for example, I think it's Reed case from Texas, that talks about a scenario in which a person provokes what they intend to be non-deadly force, and then they find themselves having to defend against deadly force and commit a murder. And the court, at least in Texas, saw because you committed the improper and immoral act of being, provoking non-deadly force, it mitigates murder to manslaughter. So there is self-defense, but it's an imperfect self-defense.
So your view is that, in fact, you don't agree with that principle as an absolute principle of self-defense. It might be mitigating in some way.
I think maybe I was unclear. It's I think well accepted in the first aggressor context, which Your Honor described. It is less well settled in the provocation context.
Why isn't being the first aggressor a very strong form of provocation? I mean, if I have an absolute right of self-defense, if I run up to somebody and push them, I think I've been pretty reckless with the idea that they might respond in a violent way that could be up to, deadly force, especially let's say it's someone I know has previously had a gun. And if I have an absolute right of self-defense against deadly force, that just seems incompatible with the idea that if I am reckless with my unjustifiable, unnecessary conduct creates a known and substantial risk of the use of deadly force. I would think that those principles can't coincide together.
All I can tell you, Your Honor, is that historically, this idea of escalation in the provocation context has not been treated identically to escalation in the first aggressor context.
But from a culpability standpoint, right? I mean, again, in the first aggressor instance, A is causing B to use violence in self-defense, right? A uses violence, B responds with violence in self-defense. So to say then that excessive force principles still apply when B responds with too much force in self-defense, that works over in the first aggressor context, but not in the provocateur context where A hasn't used force, right? This is separate from the first aggressor, right? And it's B that's initiating force. And to say that we don't apply that limit of excessive force in that instance, that makes zero sense to me.
I don't think that's
from a
right.
culpability standpoint.
I don't think that's right, only from a sort of the rules of self-defense are aligned with how people act. And so it is commonly understood that one does not react to a shove by pulling out a gun and shooting someone. And so one accepts that the person using responsive force has acted unjustifiably. However, in the provocation context, it is not as predictable that when you are provoking someone to violence and only intended to be a fist fight, how that person is going to respond. And so I think it is not totally inconsistent to treat provocation in terms of escalation differently than first aggressor.
And purposefulness, I'm sorry, we have a lot of questions, Mr. Lenners. Doesn't the purposefulness standard, though, help bring a little more clarity than a lot of the questions prompted by the panel today to you about the reckless standard and the necessity requirement that you read into that recklessness standard? Seems to me ripe for a lot of confusion and uneven application. You know, in a city like the District of Columbia, which you describe as an all-urban jurisdiction, folks in some parts of the city may never have to worry about, is it necessary for me to put myself in the path of this danger? Whereas folks in other parts of the city that may be more crime-ridden will always have to worry about that. And then the jury is faced with questions evaluating uneven circumstances, whereas a purposeful standard, I think, seems to require a little more concrete showing and a little more concrete standard for the jury to evaluate evidence regardless of the part of the city that someone might live in.
I think that this court's cases talking about the provocation doctrine for the last 50 years belie the idea that it is prone to erroneous outcomes. I think in each of those cases, the court may disagree with Laney, but in the cases since Laney, where the court has invoked the provocation standard as a reason to deny self-defense, the outcome in those cases on their facts, I think, aligns with a common sense application of who is responsible for the violence that.
What about
occurred.
Sam's? I mean, let's assume, because the instruction would have told the jury to convict Sam's anyway, but let's assume that, I believe it was Sam's co-defendant whose name escapes me. But let's assume the testimony was correct, that they've got a beef with the guy and his intent in going up to the guy was to squash the beef and say, you know, while he understood that guy might intend violence for him, he wanted to end it. And so he goes up and says, look, let's put this behind us. You think that person should be guilty if they then defend themselves and in response to the olive branch, the person attacks them?
I think under the facts of Sam's, which were that he left and went to get his friends and said, let's go get this guy.
All right, I'm saying, let's assume we don't believe that. Let's assume that the defense, you know, the instruction would have told the jury to convict him regardless, right? If you believed what all Sam's did was, I want to go back and end this fight between us that we've got. I don't want this to continue. Those facts, I think what we said in Sam's is, yes, you're still guilty. Even if that's your intent, even if you did it in the most diplomatic way possible, if you had reason to think that person was going to react with violence, you forfeited your right to self-defense. I think, I mean, do you disagree that Sam's says that?
Sam's does say that. It's the government's view that by acting recklessly to provoke this violent confrontation that left Mr. Sam's seriously injured or dead, I don't remember which, that could have been avoided. He could have tried to breach the peace by sending someone else. You know, I think Sam's was pre-text message. He could have called the police and said, this guy is threatening me. You know, I need an escort, or we need, you know, some help to resolve this dispute. I think that Sam's is properly held culpable. But if the court disagrees.
Can I just pause on this idea of necessity? Because one concept I don't really got explored in the briefs is, if I know somebody's out to get me, I'd rather see him coming, which means if this person's going to attack me, I would like it to happen while I am prepared for it, while I am facing them. And so one good reason why you might want to go and try to squash a beef and say, look, this is done, right? We're done with this, is because if this person's intent on attacking you, that attack might come via ambush. So why wouldn't that be viewed as a form of necessity? You know, you do not want people out there hunting you. And sometimes that outreach works. People squash beefs all the time. Look, let's put this behind us. Why isn't that a form of necessity?
Because there are many other ways that you could attempt to squash that beef without going there in person, not knowing how the person's
Yeah,
going
I
to
guess.
react.
I mean, it just seems awfully harsh that people, you know, I tell my kids to stand up to bullies, right? And maybe you think that's bad parenting advice or bad life advice, but it hardly seems like they should be convicted murderers if the bully, when confronted, acts with deadly force and they manage to get the drop on them and defend themselves. I mean, it seems like, I don't know, it seems like the law probably ought to say, well, that bully's life is forfeit. They're the one who promised violence. They're the one who acted with violence. Why on earth is the law going to protect them over the person who was trying to end things and stand up for themselves? It's just, and I take it your answer is partially, well, you know, life is really important, but it seems anathema to sort of basic, you know, commitments to human autonomy and protecting the righteous versus the wrongdoer instead of protecting the mob and the bully instead of the righteous.
I understand your concern, Your Honor. The government's view is that the recklessness standard, which is admittedly more protective of life and less protective of autonomy, that has prevailed in this jurisdiction for nearly a century, is correct. It's consistent with fundamental legal principles, and the court should keep it. If the court disagrees and thinks a purposeful provocation standard is what it should adopt, it should not adopt either Turner or PDS's deeply flawed and unsupported proposals. Turner, for example, takes his
About conduct. So that if, say, we adopt their, because both of them are proposing a mens rea of purpose.
Right.
But you're saying if we do that, don't adopt their proposals about carving out conduct.
That's right, Your Honor.
Okay.
That's the government's view, that so Turner's is based in the model penal code. It only applies to deadly confrontations, which we don't think is an appropriate limitation conceptually. And it adds that his acting in a manner reasonably calculated to result in death or bodily injury, which also is not in the model penal code or from any jurisdiction's statute that I can see.
Doesn't that reasonably calculated language perhaps go somewhere in the neighborhood of the necessity language that the government would favor in a recklessness standard?
It seems to add an unnecessary requirement.
An unnecessary necessity requirement?
Exactly, Your Honor. Beyond the actions of with the purpose of causing death or serious bodily injury, so the requisite mens rea, they provoke the use of force against themselves in the same encounter. So it shouldn't matter what they do to provoke that, so long as they have the mens rea and their actions actually provoke the force. We think that that is sufficient. And it's in line with the vast majority of jurisdictions that have adopted a provocation standard by code. So if you look at the various statutes cited in PDS's brief, the vast majority of them say something along the lines of, with intent to cause physical injury or death to another person, he or she provoked the use of unlawful physical force by such other person. And so it doesn't have this additional requirement that the provocative conduct, which you intend to provoke, be reasonably calculated to do so.
Can I ask you beyond statutes? I think if I understood him correctly, I think Mr. Gonan said that in his view, the reasonably calculated requirement was deeply rooted in the common law. We didn't get into exactly what the basis was for that thought, but you've been focusing on statutes. Do you have a view about whether that the reasonably calculated requirement, or really any of these requirements, would be, leaving aside how often they appear in modern statutes, how deeply rooted or not they were in the common law?
I have trouble answering that question, Your Honor. The court, a lot of courts will use that language, reasonably calculated to, but they don't explain what it means. And it often means the same, at least as I read it, the same as having the intent or purpose to provoke. A lot of these things seem to dovetail with one another, similar to your question, Judge Easterly, about what does it mean to be wrongful conduct or unlawful conduct. A lot of the cases say that, but don't really explicate it. And none so far that I read, and I read a lot of old cases and it makes your head hurt. None of them said this was with the perfect purpose to provoke and reasonably calculated to provoke, but was lawful. Therefore, the defendant, should have been able to claim self-defense, at least so far as I know. The Public Defender Service's proposal is flawed for that reason. It also improperly carves out speech and innocent presence. I mean, speech is really the big one. Looking through the model penal code, the rules adopted by other jurisdictions, none of them have this speech carve out. The common law, I think, overwhelmingly said that if you act with an intent to provoke and use words to do so, that is sufficient. The Public Defender Service
But
cite.
it's a little more nuanced, right? I mean, I'm just picking one case, Doris, that says at that time in 1908, the weight of authority indicates that merely offensive words springing naturally from the accused while engaged in a quarrel are insufficient to deprive such person of the right to self-defense, unless accompanied by circumstances clearly showing an intent on his part to provoke some kind of an affray. Maybe they're trying to say, sort of expletives tossed off don't count, but if you're really, needling someone to fight you, that could be sufficient.
So I read.
I don't know if you've seen more.
I read Doris as supporting our position. Mere words are enough, that if they're accompanied by circumstances showing an intent. So if you have the intent and the words, that's sufficient. And the Doris case, Your Honor, I'm familiar with because the Public Defender Service cited the RCL for the proposition that jurisdictions are split on this. Well, again, as with all treatises, you have to look at the sources underlying that claim. There were 4 cases in that footnote. 2 are from Texas, which clearly its law from the 19th century to now says that words alone may provoke a difficulty if they're clearly designed to do so. 1 is Doris, which we think supports the idea that words alone are enough. And the 4th is a Missouri Supreme Court case that I found hard to follow. So, their source maybe identifies 1 case at common law saying that words were not enough, whereas the overwhelming weight of authority says that it is enough. And conceptually, it makes sense. I mean, that's most often how one is going to provoke, especially in the non-homicide context. The rule of provocation is going to apply, for example, to domestic violence context, where the husband provokes the wife into some sort of assaultive act so that he can slap her. And that's often going to be words because they know each other and they know how to provoke the other person into violence.
Can I ask you, your comment about kind of escalation topics lead me to want to make sure I understand your answer to the following question, which is assume that a purpose standard was required and assume that these principles apply both to non-deadly force and deadly force. And imagine the situation where person A has the plan of provoking somebody to non-deadly force and goes and starts implementing that plan by triggering conduct of some kind, and it succeeds. And the person probably unlawfully attacks that person, and person A then responds with some force. And then person B escalates by bringing out deadly force, and person B responds and ends up killing person A. And so I'm assuming that's not a first aggressive. So it's not. I know you said that with respect to the escalation outside of this particular complication, it works differently for the first aggressor kind of cases and for the provocation kind of cases. So I think your answers to various questions suggest that maybe your answer is that in that setting, person A has forfeited the right to defend against deadly force. But I'm not sure that's right. So I'm asking you, leave aside first aggressor, but in a hypothetical where it's provocation or triggering causation, or whatever you want to call it, original plan was non-deadly force, and the ultimate decedent responds with deadly force. Has person A, because of that original plan, forfeited any right of self-defense as against the unexpected, undesired use of deadly force?
I think there's support for the idea that they have forfeited the right of perfect self-defense, but may have a claim to imperfect self-defense.
And
But
that your position is in line with that support. In your view, the right answer to that question is perhaps they're not guilty of murder, but they would be guilty of manslaughter.
Yeah, Sean. And I think, I mean, Sam's had language along those lines, which talked about provocation serving to, provocation meaning the person is in the wrong such that they might not be guilty of murder. I don't remember the exact language. I think the Gunther case from Maryland supports this view as well. But I think it's the Reed case from Texas, is the Texas law, I think, is the most clear on this mitigating murder to manslaughter as opposed to regaining the right to perfect self-defense. And that issue, of course, is not at issue on these facts, nor is it something the court has to answer. We do think the court should set forth a clear provocation standard.
Just to slow down for a second, though, I just want to make sure I parse that. So if you're being in concrete terms, let's say that, I want to get into a fight with, or A wants to get into a fight with B, and the whole plan is pushing and shoving kind of match. And completely unexpectedly to A, B pulls out a gun and starts trying to kill A, and A, from that point on, acts in lawful self-defense, gets the gun away, is trying to avoid it, and ends up using deadly force. You would say A is guilty of manslaughter because there was like kind of a plan to provoke somebody by having a shoving match.
Correct. They've acted with a guilty mental state to try to provoke this person into violence. The person responded unpredictably, as one does when provoked. I think, again, in the aggression context, typically a shoving match doesn't result in a shooting. A fist fight doesn't result in murder. Provocation is, I think, less predictable. Whether your words of using the N-word in all Black neighborhood is going to result in people beating or shooting.
What's your basis for saying provocation is less predictable? I mean, I just don't know what the basis is for that.
This law of self-defense in general talks about how a reasonable person might act. And I think that is based on common human experience. We see fistfights on playgrounds amongst kids that don't result in death. We see,
You're making a comparative of the provocation context is less predictable than the first aggressor context. And I don't know what your basis for
I'm
that
invoking
is.
sort of common sense and our own lived experience of when you, again, say use racial epithets to other people, they're going to react less predictably, I would posit.
I just don't know that it's true that if I punch someone, that I can predict that, that they should respond proportionately, and if they don't, they're at fault.
I think
Versus
society,
if I taunt someone that they're, recklessly, that they're, if that's where we are, even purposefully, if I taunt someone, that they're gonna react, with deadly. I don't know what the basis is for that. Can I just get back? We were talking about the various carve outs for conduct, and you were saying don't impose a carve out for mere words. What about mere presence?
we think that a mere presence carve out is also inappropriate. It is not consistent with the 100 years of case law in this jurisdiction, which has held that presence alone is enough. And that's separate from the mental state. There is a basis, as we cited in Short from Louisiana and other cases, that presence alone. And I think conceptually, it makes sense to say that if you are acting with a
If you look
purpose.
at our cases, sorry, you're saying that it's consistent with our case law and maybe had this thought. I mean, how many of our cases are actually mere presence cases? Aren't a lot of our cases actual there's conduct there. They're either first aggressor cases, I think there's some overlap. Or there's language, there's words, there's something else. But mere presence, I can't think of a case. Can you think of a case?
I think Howard, the farmer's market case is,
What about Laney?
well, Laney's.
Beyond Laney.
Right.
Yeah.
Post Laney, I think Howard is a mere presence case in which there's a confrontation at the farmer's market. The two defendants leave, arm themselves, and go to the house of the people when they had the confrontation. I don't know that there were words or anything else spoken, and the people living at the house saw them coming.
And what do we do then? I mean, that's mere presence armed. And are possibly mere presence armed for self-defense. It seems like the Supreme Court cases from the late 19th century say that's okay, and that's not provocation.
I don't think that's what they say. I think what they say is you cannot infer a purpose to provoke from the mere act of arming oneself in self-defense.
Can I ask about Laney? Because this, I mean, I think this kind of drives the point home strongest for me. Let's say that Laney did purposefully, by setting himself in front of a lynch mob, sort of his intent was one of them might shoot at him or attack him so he could strike them down. And let's say Laney's thought process was this. This is a lynch mob on the streets of DC. They are going to kill and maim every black man they find unless somebody puts a stop to that. So I'm going to be that somebody, and I'm going to walk out there. And if that's what they're going to do, if they're going to attack black men, I'm going to face them. And if they attack me, I'm going to shoot one dead, and I'm going to put an end to this lynch mob. So let's take those facts. It again strikes me as somewhat perverse to say the law is interested in protecting that lynch mob and in making Mr. Laney a murderer for what is ultimately an act that you think, if my mere presence is so upsetting to somebody that they're going to visit deadly force upon me, even if I know that, that's their bad. That's not my bad. That's somebody who the law doesn't need to be protecting. And this might be, but in that example, you think Laney would have forfeited under if his purpose was to instigate the lynch mob, as a black man might suspect his presence might when a lynch mob is marching up the street, especially given their previous encounter, then he had no right of self-defense. Is that right? I mean, that is your position?
Yes, if he's doing it to protect other people, then defense of a third party comes into play. And
I want to be imminent, so
I would agree with that. But I think you're not protecting the lynch mob. You're protecting life, both the lynch mob and the person who's intending to provoke, because the law is trying to get that encounter not to occur to begin with unknown consequences. You don't know who's going to die in that encounter or what innocent civilians might get shot, especially in today's day of high-powered firearms. And so the purposeful provocation standard, even through mere presence, isn't just protective of the two individuals, it's also protective of all of the innocent citizens around them. And I think the more realistic scenario in DC is crew on crew violence, where they know each other and they have a long-going feud and they know that they're going to shoot at each other. And one crew goes into the other crew's neighborhood with the intent of, hey, they see us, they're going to shoot at us, and we're going to shoot back and kill them. And that's a mere presence, which we think is properly rendered culpable under the provocation standard so that they can't claim self-defense, to prevent them from doing that, unnecessarily provocative thing.
But the DC Council is aware of these circumstances, and they don't have the same policy outlook that you do about protecting life. They've voted to go along with a different standard.
So I have two responses to that, Your Honor. The first is, Congress has plenary authority over the district, and Congress rejected this. So I think there's not a lot you can take from the ultimate outcome other than it's not the law. Second.
But when you're talking about it, it really sounds like you're being the legislature. You know, we're trying to protect life. This is what's important here. I don't know that you're getting that from Congress.
I don't think you're getting it from the council either, who enacted this provision as part of a huge comprehensive reform without any discussion of it. It's not clear that they thought about it at all. And
Well, they voted on it and adopted it.
adopted all of the revised criminal code. But I also point out, again, that the standard is.
Don't we assume that legislators approve of what they're voting on? I mean, that just seems like.
And Congress disapproved of it. And so then
Well,
you
we
assume that
know, but
Congress.
we know why Congress disapproved of it, right? There was a public debate about why Congress rejected the RCCA and it had nothing to do with the provocation doctrine.
Then equally, we don't know why why DCCA adopted it with no discussion whatsoever. But ultimately, it is out of step with basically what has been codified by every other jurisdiction, the model penal code. I mean, if this court is concerned that the recklessness standard is an outlier among jurisdictions, the proposal by PDS is equally, if not more, an outlier insofar as it requires the conduct to be unlawful and carves out speech. And again, even those other.
We were talking
you
about the
say-
near presence, though.
Yeah. Did you mean to say, I'm sorry, Mr. Leonard, that the purposeful standard is, if adopted, would be in some form, and DC would be out of step with other jurisdictions?
Not the mens rea, Your Honor, not purposeful, but the carve-outs for unlawful conduct, speech, and presence don't exist in the, I tried to look at every code section that PDS cited in its brief. I didn't look at every case interpreting it, but at least the law as enacted, I did not see any carve-outs for speech or presence or unlawful conduct. The model penal code doesn't have them. You know, most often they say something along the lines of the Alabama criminal code, which is with intent to cause physical injury or death to another person, he or she provoked the use of unlawful physical force by such person.
The recklessness standard, either the one in the jury's instruction or one with any tweaks that might be proposed otherwise, in your view, need to exclude the same carve-outs?
No, Your Honor, we don't think those carve-outs are appropriate. We think that if a person acts with the intention of provoking a violent response, and then does something, whether it's words, going into the person's vicinity, or taking an act, that they're appropriately held liable for the violence that ensues and cannot claim self-defense.
Counsel, your brief mentioned briefly a gross recklessness standard. I think you were posing it as a potential alternative if the court didn't agree with your recklessness position. Can you expand a little bit on what the difference is, but practically between gross recklessness standard and a recklessness standard on the one hand and a purpose standard on the other hand?
So we posited gross recklessness because that is the mental state required to prove second-degree murder. And so at least in the homicide context, it would be consistent, I think, to say if you provoke violence, provoke a violent response with gross recklessness, that you have the same mental state. It maps onto the mental state for second-degree murder. I think the difference between recklessness and gross recklessness is the nature of the risk, if I recall correctly. And we did posit that as a potential alternative that we think would be sort of conceptually consistent. Another alternative that at least one state has adopted is a knowledge requirement. Montana says purposefully or knowingly, and that also.
Is that by statute?
That's by statute, yes, Your Honor. And that it knowingly also makes sense because you may well know that your act is going to provoke a violent response. And we think that criminal law would properly hold you liable for knowingly provoking that, even though you didn't actually want it to happen. It wasn't your intent. You didn't want the person to shoot at you, but you knew they were going to. And then the violent response that ensues, we think is culpable, and that the blame is properly laid at the feet of the person who acted knowing.
Can I
Counsel,
just ask, oh, I'm sorry, about the outcome of this case and, this is completely hypothetical. But say the court were to, say there is a purpose requirement. And we're not going to talk about conduct limitations. Somehow we duck that issue. Do you think, it's hard to see that the instruction as given would be harmless. I mean, the government pretty much hung its hat on the instruction as given, but there's a sufficiency claim here. Can you give me your best argument as to why you think the evidence supported an instruction on provocation if there's a purpose standard?
Yes, Your Honor, and if I could just say one sentence about harmlessness.
Absolutely.
The defendant was not convicted of murder. He was convicted. And so there is a harmlessness argument, which is that the jury didn't reject his self-defense claim outright and find provocation, that it simply found imperfect self-defense, which is sort of the most likely outcome on these facts, rather than some sort of provocation sufficient to mitigate manslaughter, murder to manslaughter. It's more likely that they found imperfect self-defense, which means that the forfeiture of self-defense didn't come into play. But in terms of why the evidence would be sufficient, you had three confrontations.
And specifically to give a provocation
to give a purposeful provocation
Yeah.
instruction. You had a series of three escalating incidents during the first of which Jamphy, the victim, said, "You better smoke me," and Turner said, "It's a bet." He then walked back to his car where presumably his firearm was located. There was testimony about the size of the bullets being too big to fit in a pistol that would fit in Jamphy's pocket. It was effectively a Draco, a small assault rifle bullet. Turner goes to his car where his gun is, drives back. As he cuts
Just
off
slow you
the
down there,
sorry.
because you omitted one thing that there was at least some evidence of and some discussion of in your opponent's argument, during your opponent's argument, which was the testimony about a statement about when I come back, I'm going to kill you. Do you have a position about whether, as your opponent argued, that's just inconsistent with incontrovertible evidence and therefore shouldn't be considered by this court in answering the question?
I don't think that that's right. I think the court should consider the threat that Brady testified to. Brady and the other civilian witness both testified consistently that the angry guy who was walking away did things, and that was Turner. He was angry throughout this and was walking away to get his car. And Brady testified that the man walking away was yelling at the other guy saying, "When I come back, I'm going to kill you."
And the
Jamphy wasn't-
response to that is, "I know." But when you watch the videotape, the person who says, "I know," is Mr. Turner. So it makes it seem like the person who said, "When you come back, I'm going to kill you," was actually the decedent.
Given the testimony, I don't think it's impossible that the person who said, "When I come back, I'm going to kill you," was Turner. And thus I think the court, in terms of
He's
sufficiency
just
of
talking
evidence.
to himself. He says the whole thing.
I mean, I am not going to sit here and parse the video. I think it's on these facts, given the evidence that came in, plausible that Turner said.
Do you disagree that you can hear "I know" on the videotape, or?
I haven't listened to the video, Your Honor. I'm sorry.
Okay, that there's a lot of record evidence.
There's a lot going on in this case, and I didn't know that sufficiency would be a big part of the argument. But then, so Turner goes to his car where he gets his gun. There's a second confrontation.
I'm sorry, just to pin you on that. Is there testimony, is there actual evidence that the gun is in the car, or that's the inference that the gun is in the car?
The inference is that the gun is in
Okay.
the car, given the size of the bullets, meaning what the size of the gun would be, which there was testimony about. And the fact that, when "you better smoke me, and when I come back, I'm going to kill you," suggests he didn't have a gun at the time. So Turner goes to his car. There's a second confrontation in which he wields the gun. And then there's this third confrontation in which, instead of driving through the intersection, Turner stops at Jamphy's car, has another verbal confrontation with him, and then doesn't leave, but stops
Is
his
the
car.
gun displayed at the third incident?
I'm sorry?
Is the gun displayed The third- when he
It's
drives-
at the second
At
incident,
the second, when they both walk away,
when they both drive off. Yeah,
right?
they drive off. But it's circumstantial evidence of his intent during the third.
I'm just
provoke-
thinking about this sort of withdrawal, like they keep coming together, yelling at each other and walking away.
I think all of these circumstances are relevant to the jury's inferring what Turner's intent was. I mean, that's what we argue in cases all the time. It's what jurors do all the time, is they look at all of the circumstances to figure out what was this person thinking, because there's generally no direct evidence. And so we think that these previous incidents of, threatening conduct where Turner has a firearm during the second one are evidence of his intent to provoke, from which a rational jury could find a purpose to provoke, especially when during the third incident, even if Turner didn't know Giamfi was going to be there, he didn't stop, or he didn't continue on. He stopped next to Giamfi's car, and then when he drove off, again, didn't drive off, but stopped in the middle of the intersection to have this.
And
violent
again,
confrontation.
just to pinpoint you there, when he drives off, at what point does Mr. Giamfi get out of his car to chase after the car?
So there was testimony that when Turner parked next to Giamfi's car, Giamfi came around behind Turner's SUV and Turner drove off into the intersection, and then Giamfi ran at him. But
Okay.
Turner stopped.
That sounds an awful lot like Mr. Turner's trying to get away from Mr. Giamfi.
If Turner wanted to get away, he could have just driven straight or made the turn and kept driving. There was no circumstance under which he had to stop. But again, this is about sufficiency of the evidence and what a reasonable jury could infer from the evidence. And then there's.
Well, we're just talking about whether provocation instruction could even go to a jury.
Correct.
Yeah.
And I think you have to view the evidence in the light most favorable to the government under those circumstances. I don't think the defense disputes that you have to look at all these factors in a light most favorable to, could the jury have found provocation? So in light most favorable to the government. Turner appears to have been ready with a firearm. Giamfi is shot almost immediately upon opening the door. And then afterwards, Turner doesn't act like someone who just accidentally killed his cousin, who was like his brother. He doesn't say, oh my God, I didn't mean to do that. He doesn't he's on the phone with his friend. He doesn't even mention that he just murdered his cousin with whom he was intending to move in when they go off to dinner. And then on jail calls, he denies that it was self-defense repeatedly. So we think under those circumstances, a jury could rationally find the purpose to provoke such that it would be proper to give that instruction.
So counsel, while you're talking about inferences, I want to pull you back to the 10,000-foot level again. I wanted to hear your answer because I asked your opposing colleagues this before. I was having trouble particularly with the idea of gross recklessness and purposefulness, of understanding that where the difference was more than semantics. Would it be your position that if there was gross recklessness in a scenario, whether this one or others, that would necessarily lead to the possibility of an inference of purposefulness, or allow a jury to infer purposefulness from?
I'd have to think about, I don't know if every circumstance under which grossly reckless behavior allows it inference of purpose. I think the answer is probably not. I think there are probably lots of circumstances, at least posed by the hypotheticals, in which it would be improper for a jury to infer purpose, notwithstanding its ability to find gross recklessness, but it's not something I've thought about.
Is there anything else on sufficiency that you would want to say that you feel like you didn't have the opportunity to prepare?
I don't think so, Your Honor. I mean, this idea about what the video said and who's saying what, I don't understand to have been raised in his opening brief. When I reread it sitting there, I didn't see anything about a claim that it was in fact Turner who said, when I come back, I'm going to kill you. But again, this is an evidentiary determination for the jury, not, a re-litigation of the circumstances below for this
I
court.
mean, it would be sort of funny to goad somebody so if the sequence of events is, Mr. Giamfi says, more or less, you better kill me or I'm gonna kill you first. And the response is, that's a deal. I'll kill you first. I mean, in what sense could that be evidence that he had a purpose to goad Mr. Giamfi into deadly violence? Mr. Giamfi has already stated his intention to engage in deadly violence. It sounds most naturally to me, and I understand it might be a jury question, but it sounds like take your shot, but I'm gonna win if that's what you want to do. Not that's what I want to do. It sounds like you are the one who is proposing a violent confrontation. Okay, if that's how you want it to go, I'm telling you, I'm gonna get the drop on you. It doesn't sound like he's trying to goad him. I mean, you can't goad somebody into something that they're already intent on doing, right?
I mean, I think that the question is whether when Turner stopped at the intersection on the third time, he had a purpose to provoke Giamfi to violence. And knowing that that Giamfi has already proposed violence and that Turner is now armed, I think the jury could infer that his purpose in doing that and not leaving the scene, not continuing straight, not turning, but stopping, stopping at Giamfi's car and then stopping again.
Did the government impede? I'm just curious if it was if there was sort of an attack on the testimony that what Mr. Turner said in that moment is, why don't you just go home? Did the government try to cast doubt on that? I mean, that doesn't sound like a purpose to goad. It sounds like a purpose to defray. But maybe you said, oh, that's just one witness and they're being self-interested or something. I don't know.
I don't know that. I don't know the circumstances of whether the government attacked that statement.
I don't either.
Thank you, Mr. Lenners.
Thank you, Your Honor.
Appreciate your argument. Rebuttal, Mr. Clark.
So I think just a few things based upon the actual questions that you just had here. It is clear, well, the instructions as they were read to the jury permitted the jury to believe that Mr. Turner simply could not be anywhere in his neighborhood. And at trial, the parties thought that the issue was more about whether or not Mr. Turner had some idea that Mr. Giamfi would be waiting for him at that intersection if he went there, knowing that his presence would therefore be able to create trouble. But the instruction permitted the jury to actually find it in a completely different way. And they concluded that Mr. Turner could not claim self-defense because he was in that neighborhood, because he was in an area where Giamfi would possibly know to look for him.
Why do you say that the jury concluded that? I myself don't really know why the jury reached the verdict it did. So do you think it's somehow clear that the jury relied on the provocation concept rather than other concepts that might have got them to its verdict, to their verdict or its verdict?
I mean, the basis is I talked to the jury, but I know that the court can't really give that an evidentiary weight, but it certainly is a possible interpretation of the instructions. And what it really highlights is that as long as that is something that a jury could do, that shows why this instruction is so problematic and so biased.
But that wasn't the universe of the evidence. It wasn't, the government's theory was not based purely on the fact that Mr. Turner returned to the area. It was also that he pulled up next to Mr. Giamfi's car, then peeled away, and then stopped.
That is the more specific argument that the government made. But the government's closing argument and their rebuttal and closing argument is largely determined upon Mr. Turner making poor choices about remaining in the neighborhood, about going down the street. And they do argue that he has some reason to believe that maybe Mr. Giamfi is still in the area. And that alone should not be enough to result in somebody forfeiting self-defense.
One thing Mr. Leonard says, which I think is quite interesting, I haven't given it enough thought, is really the best way to understand the jury verdict, where they acquitted of murder and convicted of voluntary manslaughter, is probably not that they relied on this sort of Laney forfeiture concept in reaching that verdict, but instead on excessive force, that maybe Maybe you were in, maybe Mr. Turner was in reasonable fear of serious bodily harm, but he acted with deadly force when he didn't need to. Seems like a pretty good argument. Well, why do you think that's not the best interpretation of the jury's verdict, or one pretty plausible one?
I don't think it's plausible. Maybe I'm biased on this. I think that if we look at it objectively, it cannot be the case that somebody in Mr. Turner's position being assaulted in the way that he was at that intersection, having a man who almost double his size, almost double his weight, extremely just dwarfs him in every manner, has now ripped open the door and is inside on top of Mr. Turner assaulting him. And Mr. Cooper tells us that, you know, he sees the struggle and that Mr. Jumpy is assaulting him at that point. And it cannot be that he does not have a reasonable apprehension of at least, at minimum, significant bodily harm at that point. And so I just don't think that it is possible that the use of force, the amount of force, is the primary issue here.
So do you mean, you think that it would be error for the jury to have been instructed on excessive force then? Because this is a matter of law, this was reasonable force.
I mean, I don't know about error, that they would usually be instructed in that way, but I do think that as a matter of law, it was not excessive force.
Did the government argue in rebuttal excessive force? I don't remember that argument.
They had one,
They argued provocation,
they
right?
they argued provocation. That was
And then
their
they said
primary.
the other way it works is in looking at the actual self-defense instruction and argued,
Their
well,
argument,
he wasn't scared.
their argument was that Mr. Turner basically shouldn't have been afraid of his cousin. That because they were brotherly, because they were so close, that Mr. Turner essentially shouldn't have feared him because he was family. And I think that this court is well aware that there's plenty of cases where you have every reason to fear a family member, and that just because they're family doesn't mean that they don't mean you some sort of significant bodily harm. That was the basis of their argument as to why he couldn't reasonably apprehend fear at that point. It was just because they knew each other, right? I think because they knew each other, he did reasonably apprehend his fear.
Maybe I missed it in your briefing, that the government brought up here and brought up in its briefing that at least 2 prison phone calls where Mr. Turner disclaimed self-defense. He hit himself. If I missed it, I apologize, but what was your response to that and how we should consider it in any way?
So I think maybe because of Laney, but for the last 100 years, there is a strong belief in the community that there is no such thing as self-defense in the District of Columbia. And I think that every defense attorney in town who's been doing this for a while has heard their clients explain to them that there's no such thing as self-defense in the District of Columbia. Mr. Turner does not say that he did not act in self-defense. What he says was self-defense. No, this isn't that kind of a town. You don't get that in DC. And I'm paraphrasing here. And he is not making a statement about his mental state at the time. He doesn't say like, oh, well, I wasn't afraid. The other thing is the context.
I thought he said he shot himself.
Yes, he does. He does say, additionally, well, the man shot himself. The context of this call is that this is not immediately after the incident. This is 19 days later. He has just been arrested and he is on the phone with his mother. I mean, this is another family member, and I would give you that Mr. Turner has an ego, that he wants to come off as some sort of a way, and he is talking to his mother, explaining how he and his cousin got into it and his cousin ended up dead. And so it is not a confession that it was not self-defense. It is merely a man talking to his mother who does not believe that he's going to be able to claim self-defense in the District of Columbia. And if there's nothing further, with best regards for my briefs, ask the court to reverse.
Thank you.
Thank you.
I think we did ask you, I'm sorry, you said reverse in instead of remand, and I think we discussed that.
That would be
earlier.
I do believe that without the provocation instruction, the evidence here never would have sufficed. The jury could not have actually convicted him. So I would ask this court to reverse.
And that's on all counts, including the felon in possession count, in your view?
I would. Admittedly, the felon in possession count is a little bit of a different animal. I've made those arguments in my brief. And if you have any additional questions, I'd have to answer them.
All right, thank you.
Thank you.
All right, Mr. Gonan?
Thank you. I have 4 brief points and then just a final broader point, but it'll also be quick. And I can confirm what Mr. Clark said about the common conception that there's no self-defense as a matter of law in DC. That is, a lot of people believe that. Okay, so Mr. Linares, I believe, can agree that the reasonably calculated construct is deeply rooted in the common law. But I think he said it's unclear what that means, but it is clear that it is an objective standard. We cited cases in our reply brief that talk about that. It's essentially equivalent to, would be provocative to a reasonable person under the circumstances. The second point, and I know
Why wouldn't we want that carves out, I'm getting my carve outs and my add-ins mixed up. But that excludes provocation of like the eggshell complainant, right? You know, I know Judge Steele gets really, really irritated when I, sip my water loudly and I just continue to do it next to him until I provoke him into punching me. Why would that be okay? Why would that be non-culpable? If he has this sort of unreasonable sensitivity that I exploit.
I think for the same reasons, it wouldn't be culpable in the context of threats or assaults or robbery statutes, that there's some sort of objective standard that comes in. It's not just all about you take people as you find them. That if it's not provocative to a reasonable person, it doesn't matter that you have an unusually fearful or an unusually brave person, or an unusually calm or an unusually violent person. If you have an unusually violent person, you should be able to defend yourself when they react unreasonably to slight or trivial provocation. And that is the common law standard. I know
So how they react, it's not what the sensitivity is, I guess.
Yeah, it's
Another
whether
way
their
maybe.
reaction is, reasonableness, proportionality. These are very important concepts in self-defense and in criminal law more broadly. So it's not a surprise to find it in this context. And again, as I said, it is, I think, undisputedly something that is deeply rooted in the common law. Second point, I know we covered this a lot, but just to reiterate, our position is that the common law is split on whether words could be provocation in both mitigation contexts and forfeiture contexts. Our position is that this jurisdiction has taken a side in that split. And at least in a case where that doesn't involve provocation by words, this is the case of the provocative U-turn, but not really anything about provocative words, that there's no cause to revisit that issue or revisit that decision to say mere words are never reasonably provocative. The third point is, I do want to say that the common law was definitely clear on the notion that presence alone could never be reasonably provocative.
Can I ask you about that?
Yeah.
I definitely find cases that say that, but
Right.
are there cases that say that presence alone is not enough? There's an ambiguity in what alone means.
Yeah.
Because if you mean presence alone, are you excluding a culpable mental state, or what are you including?
We
So
look-
cases that will say presence alone is not
Sure.
enough,
So-
even
so-
if it is accompanied by
Yes.
an evil plan to goad.
Absolutely. Many cases say that, and I think State v. Short, which the government cites, is one of those cases. Remember, that's the case I talked about earlier, where they reversed, saying you didn't really make it clear enough to the jury that you have to have more than a purpose to provoke, you have to have some provocative act. And then on the retrial, it came up again, and the court said, well, under the peculiar circumstances of this case where you expressly were offered a peaceful resolution and you affirmatively said, I don't want a peaceful resolution, your presence under those circumstances was reasonably provocative in that unusual scenario.
And I mean, you think the idea that it is deeply rooted in the common law cases that make clear that they're not speaking generally about presence alone is not enough, but they're saying presence alone even where accompanied by a plan to go. Because I can't say I was able to find that as deeply rooted in the common law, but
They're cited, those cases are cited in our, I think both our briefs.
I certainly saw some cases that say that. I guess it's a question of what deeply rooted means.
I guess there's no cases that say the contrary. Now, I do want to say, you know, Mr. Linares talked about there are some modern statutes and they don't have a speech or presence carve out. But I think it's pretty clear if you look at the modern case law that courts interpret the word provoke to be some kind of, right? Those statutes say you have to intentionally provoke someone. So the provoke, it's not like you have to intentionally want to be attacked and defend yourself. You have to provoke. And courts have interpreted provocation to have this affirmative unlawful act requirement. For example, State v. Riley is an Oregon Supreme Court case that we cited in our brief. They have a modern statute that codifies provocation. And they have, in Riley, they said words are never going to be reasonably provocative conduct. Texas also has a codified self-defense statute, and they, in a case called Elizondo that we cite in our brief, they affirmatively say the statute did not displace the existing common law of what constitutes provocation. Mr. Linares did mention Montana. They do have intentional, that's the only state statute that has this knowingly standard. I just wanted to flag that their statute, if you knowingly provoke violence, it triggers a duty to retreat in deadly force cases. It does not forfeit self-defense by itself. And the final sort of broader point I wanted to make is that the court has very two powerful forces on either side of it. There's the common law, in which these principles that we're advocating for were deeply rooted, brackets around the speech issue. And it has the DC Council's view in the Revised Criminal Code Act of 2022. And for this court to depart from deeply rooted common law principles and adopt a standard that is different from the standard that the legislature itself adopted would be unprecedented. And the court would be essentially substituting its own judgment for the views of the elected representatives of the people of the District of Columbia. And Congress did disapprove that law, but I have been through the congressional record and all of the public statements, and I can confirm that not a single person ever took any issue with any aspect of that law other than the three things: change to the certain penalties, increased second look, and increase in jury trial rights. Those were the only issues anybody took with that bill in any public statement. And to the extent we don't know what Congress's intent was, well, we do, because when Congress passed the 1901 DC Code, it incorporated the then existing common law. So I would urge this court to follow the lead of Judge Schwelb and his opinion in Little, which is where the court refused to change the common law.
But wouldn't the then existing common law have been Laney?
No, because Laney postdates the adoption, Congress's enactment of the DC Code. So Laney was, depending on how you read it, a departure from settled common law principles. You know, I actually don't read it that way. I read it as misapplication of settled common law principles. But certainly it was not something Congress had in mind when they passed the code in 1901, because Laney came out in 1923. So, you know, Judge Schwelb said, even assuming in Little, Judge Schwelb wrote, even assuming this court has some power to broaden the scope of criminal laws beyond what Congress enacted, it should do so with restraint, lest we intrude upon the prerogatives of the legislative branch and the liberties of the citizen. Sharing the Supreme Court's instinctive distaste against men and women languishing in prison, unless the lawmaker has clearly said they should, we conclude that the legislature and not the court should decide whether the common law rule, which is by no means a capricious obstacle to a prosecution, should be retained or revised. That was a case where the legislature was silent on this issue. The legislature has not been silent. The council unanimously passed the standard that we are asking for. The mayor agreed, even though she vetoed the bill, she proposed her own version of the bill that had that standard. So the elected representatives of the people of the District of Columbia have spoken, and this court should not be in a position to adopt a standard contrary to that one.
If we don't buy that argument about the law that the council attempted to enact,
yes,
but is not the law right now.
It's definitely not the law.
If we don't buy that argument, then what other basis do we have for overruling or setting aside Laney?
the common law, Supreme Court precedent, the weight of modern authority. But I'm not suggesting the court has to do what the council did as a matter of legal obligation. What I'm suggesting is a matter of judicial restraint. It would be extraordinary and I think unprecedented for any court probably anywhere in the country to say as a matter of judicial lawmaking, we are going to adopt a standard that is directly contrary to the standard that our own, state legislature adopted just a few years ago, and that didn't become law for sort of unrelated political reasons. That I think would be unprecedented and be an improper use of whatever,
Could
judicial
any
power.
court in the country
this court
ever
had.
end up in that same scenario?
I'm sorry?
Could any other court in the country ever end up in that same scenario? I mean, I get the appeal of what you're saying.
Yeah.
But we've got a Home Rule Act and we've got our own role
Yeah,
in the charter and whatnot, and Congress has its role.
well,
And so I
this-
get the persuasive authority of it, but this seems to lean a little hard, and it seems like I could equally, for taking a devil's advocate position, say, oh, well, we'd basically be invalidating a role from the Home Rule Act to go your way there when it didn't become law.
well, again, we're not asking the court to change the law. We're asking the court to follow the common law rule, which happens to be pretty close to, if not exactly the same as what the council enacted. So that's why I said there are these two powerful forces and they both point in the same direction.
Do they, with respect to your suggestion that the concept of unlawful conduct be a limitation?
I think that comes from the common law. I acknowledge it's not expressly mentioned in the RCCA. So if the court wants to get rid of that aspect of it because
Where the two forces point in different directions, which do you think is should
The
be a
common
stronger
law.
influence on our thinking?
the common law, because in
And
our
you
view,
think- And you think the requirement of unlawful conduct is deeply rooted in the common law as well?
yes.
And if you were going to say what the common law's deeply rooted concept of that means, what would you best point us to some explanation in the common law of what that means?
Well, there are many cases, right? I think it's, in some sense, it's a numbers game, right? Because if you don't have, there's not like one person who like defines the common law. But if you look at all the treatises, if you look at all of the cases, which is what the court did in Little, right? There wasn't a specific DC or Supreme Court case that said, here's what accessory after the fact is. So they look at treatises and they looked at cases and they said, this is the common law. So when there is a clear common law rule that's espoused in many cases and many treatises, and nobody's really saying, actually, that's not the rule, or that is the common law rule. That is presumptively.
To clarify my
Yeah.
question, do you think we can find in the common law a good explanation of what that means other than the word itself? Is there some place you would say, yes, here's a treatise or a common law decision that will tell you what that means?
What the word unlawful means?
Yes, in that setting, like how to understand that term?
I mean, I think it probably means a violation of law. I don't know if it means a violation of
Right.
criminal law, but
And you're telling me what you infer it means. My exact question was,
Yeah.
do you think there's a place?
No,
that
I
the
don't
common
think so.
law or a treatise explains what it means?
I don't think there's a specific, so I would acknowledge that the court can decide what it thinks unlawful means if I'm right about that.
Thank you.
But unless the court has any further questions, I agree that the case should be reversed.
Right, thank you. The court wishes to thank counsel and Amici for your excellent briefs and arguments in this matter today, and we will take the case under advisement. Thank you.
All rise. This honorable court is now adjourned.